Hey, what's up, guys? Welcome to Law Spanning the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. And with me today, returning guest champion, Mr. Uncivil Law. How's it going, man?
The one and only, yes, I'm having a very decent day today.
I'm
And I
glad to
was
hear
very
that.
happy to hear from you and happy that we could do another stream. It feels like it's been too long, Nick.
That's what I was thinking. Like, legitimately, I was like, God, I have not had Kurt on forever. I barely even talked to you in the past month.
I can't help noticing that Drex has appeared a lot more times than me. I'm feeling unloved.
Yeah, no kidding. Oh my gosh. I got I got weak wrists. I was opening a drink. So yeah, man. So here's the story. Here's the story. I was thinking about topics to cover today, and there are a couple topics that have come up, and they're mostly in the title. So I'll kind of run through what's on our agenda tonight, and then I'll tell you why. I was like, oh my gosh, I should talk to Kurt. So I've got that you're joining to discuss the Critical K, which is an interesting a true crime YouTuber, the Critical K, and then I've also got in there the child pornography judge from Wisconsin because we not we but me and the chat talked about the child pornography judge from Wisconsin a while back. Do you remember when everybody like lost their minds because they found out that there was a group that was bringing in drag queens to read to kids at libraries?
Yes.
This judge is the former CEO of that organization. So that was a weird sort of.
Let me make sure I completely understand. You're telling me the CEO of an organization which brought drag queens to read to children is also somehow involved in child or CP? Whoa.
And
Those two things don't seem correlated at all.
not a bit. And also happens to be a family in custody. Well, happened to be a family in custody judge elected up in Wisconsin, ousting a Scott Walker appointee.
Well, I'm sure that he's in the perfect position to know what's in the best interest of children, which is his principal job as a family judge.
Right.
So, yeah.
So and the oh god, and then the other topic I have listed here is
On the plus side, I suppose he is more likely to be able to identify potential people who might be a danger to children, since he can recognize them from subtle signs the rest of us might not pick up. So maybe he is the perfect person.
He's like, I see a danger to children every day.
Yes, I see that because I exhibit that exact behavior. I know what that means. I picked up on that clue. So maybe he's the perfect person. I don't know.
And so then the other case or the other issue is bad defense attorneys, which I think is in Utah.
Yes.
There's a okay. Someone sent this to me in an email the other day, and I was like, I don't know. Like, I could barely understand the email, but there's some convoluted thing where it like a guy is supposed to show up for a criminal trial. He's a couple minutes late. And the judge is like laying down the law while his attorney just stands there and says nothing. But the guy was actually there getting booked in. And then there's like another defense attorney. And it sounded like a soap opera to me.
Yeah, the defense attorneys are more the interesting aspect than the judge at this point, at least to my mind. When I reviewed the case initially, I got completely lost in the judge's behavior. And I'm like, oh, okay, this seems all right. And then I took another look at it with the defense attorneys in mind. I'm like, oh, there are questions here. I'm not really sure what's going on here, but something doesn't smell right to me. So,
Yeah. So I was hoping we could kind of talk through that and get an idea about it. And then one of the issues I have that I want, why are you not working?
I don't know why you're about it's not working. Work on programming it better.
It's the no, not you. The super chat page is not functioning.
Something on YouTube is broken. Wow, that's shocker because
yes,
YouTube is a great company and
For you, it was the worst day of your life. For me, it was a Thursday.
Yeah.
So anyway, well, I'll get that fixed. But no, I've got a big show tomorrow. A big guest, I guess. His name is Jeff Younger, and he is the father of James Younger. And this is a Texas family law case that was really in the news quite a bit last year. And it's the Save James case, if you remember this one.
All I heard was tomorrow I'll have on a big guest, and then ran through the implication in my head, and yeah, so great.
Oh, come on. Stop it. No.
Tomorrow I'll have on a big guest. Whoa, that sounds good for you, Dick. I guess good night. Sorry, wasting your time here.
Oh my God. I was going to have no guests tonight, and I was like, I'll make this show much better if I bring Kurt on to talk with me. So now I feel like I've done a bad thing instead of doing a good thing. So thank you.
No problem. Happy to help.
So I've got this big guest coming on tomorrow. He's so the Save James thing is about this kid, James Younger, caught in a custody battle where the mom asserts that at the time, I think 7 years old, James preferred to be addressed as Luna and was trying to get James into gender reassignment therapy. And the dad said, hell no. And a big custody battle ensued. And then he recently just lost all custody. So the Texas courts have aligned with the mom, although they did say that she cannot use puberty blockers, and she cannot do gender reassignment surgery without permission yet.
Okay. Well, fair enough. I think this is a 7-year-old we're talking about, right?
I think he's 8 now.
Oh, that really is going to make a difference in this analysis. Yeah. Either way, I'm not sure. Okay, I actually am sure that a 7/8-year-old should not be able to consent or participate in puberty blockers or gender reassignment surgeries. I think that children have all kinds of thoughts, and yeah, and I have many thoughts on this issue, and the fact that there's even someone contemplating about it is distressing me a little bit, to be honest. If you're over the age of 18 and you want to get something done, knock yourself out. You're an adult, do whatever the hell you want. But, for a 7-8-year-old, I'm going to say no. How about that?
I think that's a fair assessment. I'm trying to even think of an example today. My 10-year-old comes up to me and says, Dad, I need an 11-letter word. I was like, this is the concern of a 10-year-old, because there's some game that required an 11-letter word. Can you think of an 11-letter word off the top of your head, by the way? It took me a minute to come up with one, but
I was trying to think if the word 11 technically qualifies as an answer.
No, it had to have 11 letters.
Yeah,
not a lettered word of 11.
Yeah, so I was trying to, do a dad joke thing there, but yeah. No, an 11-letter word, I don't know. Nothing off the top of my head.
Masterpiece. That's what I came up with, okay?
Masterpiece. There you go.
And so then he comes up to me about, 10 minutes later, and he's like, oh, Dad, I actually needed a 12-letter word. I'm like, masterpieces.
Masterpieces.
Get out of here. So, but this, here, these are the concerns of children. This is what I'm talking about. Gender identity. Oh, and yeah, someone in the chat correctly pointed out this has actually been going on for 7 years. The kid was 3 when this started.
Okay, apparently. Someone in chat or you are going to have to help me out. How did anyone come to the conclusion? First of all, did a 3-year-old have an opinion? Because that would be amazing. Second of all, in the absence of that, how did anyone come to the conclusion that this 3-year-old really was the opposite gender, and how does that conclusion work? Out of raw curiosity.
Well, you've seen it, right? Like, actually, I know this to be true because I've been on Twitter And I know you've been on Twitter. I know you don't like spend a lot
I
of
don't
time
like going
there.
on Twitter because it's a very sad place, and I don't go on there very much because it pisses me off.
But listen, you've seen the tweets, right? There's someone with a blue check mark, and they're like, my 3-year-old came up to me today and they said, Mom, I don't understand why the people of color are being oppressed by the by the socioeconomic, whatever. It's like,
I'm having
yes,
trouble. I'm having trouble with 3-year-old saying any of these words, really, to be quite honest.
exactly. But those posts happen all the time. So
If they got past mom, I'd be kind of impressed, you know?
since I know that those posts are true, I also know here that that the 3-year-old made a conscious decision to be.
I'd also like to rant about Reddit a little bit on the same vein.
Yes,
because
always.
I spend more time on Reddit than I do on Twitter by far.
You spend time getting banned on Reddit forums.
I know, including from /law, which was hilarious. I got banned from r/law, and my sin was the one of the moderators was saying about the Capitol riot cases, saying this. First of all, the idea that people weren't taking it seriously was an idea that was expressed, and then what he said was the Capitol riot cases aren't complicated, and I said yes, they're incredibly complicated. You've got, depending on where we're going to end up at the end of the day. Well, I think we've got 500 so far. Estimates were between 800 and 1,000. So somewhere in that ballpark of cases. Each case has to be assessed individually to determine who did what, when. We have to assess evidence. We have to get it together. We have to provide it to the evidence. We have to consider defenses, consider the possibility that some of them might not be guilty of crimes. Some of them might actually be innocent, so it's complicated. And then I got banned for saying it's complicated. On r/law for saying, hey, law might be complicated. Maybe it's not just as simple. And apparently that was an unacceptable opinion.
No, it's simple. They all go straight to prison forever because they're obviously all guilty and they could have no possible affirmative defenses. And it's not like the government just put out a motion I think a motion response specifically on the Brady rule because there's a bunch of exculpatory evidence that they haven't disclosed. And then there's another judge out there who's really getting mad that they keep arresting people because every single arrest in this case means that every other defendant has to be served all of the discovery from basically every new arrest, because if there's anything that's missed, they go. So what happens is,
I don't know if that's inherently obvious because every case is independent. So it's not inherently obvious that something in one case would be discoverable in our case.
Right. It's not inherent, but the defendants are requesting discovery every time a new arrest is made because they're pulling in new witnesses on some of this stuff, and so then these dockets are just building up, and the discovery files getting bigger and bigger and bigger, and the judge is like, why are you taking so long to prosecute these cases? You're still arresting people 7 months out instead of actually prosecuting people. And here's the problem. They're sitting in jail, right? In some of these cases, they're sitting in jail. And it's like at some point their due process rights are going to be violated.
Well, I see speedy trial motions coming up for, a lot of these people because the defense, usually time is something the defense wants. But in this particular situation, you'd be thinking as a defense lawyer, maybe I should be filing that speedy trial motion, get this dismissed on a speedy trial motion, make them go away. That'd be great.
Yeah. Yeah. And so the exculpatory evidence issue is a big one because the government's acknowledged that they may be in possession of, video of officers letting people in, video of officers fist bumping and high-fiving rioters and stuff entrants. At that point, if you're let in, you're an entrant, I think. And so that could be, for some of these cases, exculpatory. Like you said, it's complicated. It doesn't necessarily mean that everybody's guilty or everybody's innocent, but they're all individual cases.
Yeah, and even if that's true, it doesn't necessarily nullify all the charges, right? Because even if they're let in to the building, okay, you've got past the trespassing charge, basically. And then you can go into other analysis, like, okay, you can still get violence or destruction of property or unlawful parading, which they always put in this, which I think is hilarious. But yeah, there's other charges that would still survive. But yeah, that I was let in the door by someone and fist bumped along the way might work for some of them. Definitely won't work for some of the other ones. But yeah.
Right. Yeah, but that's the thing is, so like with every one of these cases, there's a big difference between a guy who goes into the veranda or whatever and takes a selfie, a guy who goes and sits at Pelosi's desk, and a guy who is punching a Capitol police officer. Like those are all very different and very complicated cases. Well, I mean, the punching a Capitol Police is less complicated, I think, but of the three, I think that would be it. But yeah, so the weird thing about Brady motions,
the DE agent who wasn't on duty but decided to go to the Capitol with his gun and display his badge and gun as he was on the Capitol. I'm like, well, last time I checked, and 18 USC 930. So yeah, good. That's great.
But the interesting thing about that is, though, with a Brady motion, the exculpatory evidence doesn't have to actually exonerate you. It just has to be evidence that would undermine the confidence of the prosecutor in bringing the case. So it might not have cleared the person, but if the government withheld it and they succeed on the Brady motion, their charges could be dismissed in theory, even though they might not have prevailed if the evidence had been disclosed, because that's the protection.
So that's just the dream. The DC District Court is already thinking ahead, because it's like, oh my God, because if there's a Brady violation, that means the Court of Appeal could very well reverse it, and we'll have to do all these all over again. New trials for everybody. It's like, so how many times are we going to have? How many trials? How many can I transfer these anywhere else? Anywhere else, so to take off the load. I don't know what federal law allows for, actually, incidentally, for that, whether or not that's allowable to transfer it to other places in this situation. But
yeah, I don't know. Oh, one weird thing, guys. A lot of people asked about my shirt today. It says alcohol is the KY jelly of the mind. That is an old quote from me. And someone made it into a shirt and sent it to me. So
would you like to explain the thinking behind the quote?
It's alcohol is like a social or a mind lubricant, right? It gets things slippery in there, so you drink liquor and the mind gets lubricated. It's like oiling the engine, gets it going.
Okay. And then there's intercourse with your brain?
Not necessarily.
Okay.
Lubrication doesn't always lead to intercourse. How dare you?
If it's like KY, it probably overwhelmingly does.
It's a therapeutic lubricant for various purposes. I cannot believe you would reduce it to these non-puritanical acts.
And what percentage of the time do you think it's used for these non-puritanical acts?
Enough.
Just out of raw curiosity.
Enough to sustain my argument.
Sure. Okay. So if we had the red balls and the blue balls in the bag, as it were, and all the red balls represent the puritanical acts, and all the blue balls represent the non-puritanical acts, and I ask you to draw a ball at random, what color are you expecting to draw out?
This color.
Excellent. Okay. Very good.
Ooh, yeah. Getting lubed up. Perfect. So anyway, I just I wanted to address that because people were asking. You could only see the top line.
I mean, if you want me to backwards. F you up now, I can try harder.
No, you don't have to.
Okay.
Okay, let me read a couple of the early super chats that came in, and we'll jump into these topics. F Gusto says, found a fellow Texan that may be Nick's brother from another mother. Black Pants Legion does Battletech lore, loves whiskey and cigars. Would be a great show. Hate Machine is after him for doing a show with Arch. Oh, good. My kind of guy. I'll have to reach out to him. Isaac Maccabee says, please don't let this slovenly, spurgy fud speak authoritatively about the Second Amendment. I think, is he talking about me? Uncivil Law is a bitter and desperate status who is clueless about most things, but especially gun rights. Damn.
What? That's a particularly harsh comment. I'm pretty well informed on gun rights, and I'm pretty pro Second Amendment, all things considered. I have a very informed view, and okay, whatever.
And then Michael Malice's, this is a follow-up to that. Michael Malice's book is a series of essays and does not need to be read in any particular order. Of note, I think you will really enjoy Lysander Spooner, Murray Rothbard, and John Hasness. Send it if you want. I don't know if I'll get around to reading it anytime soon because my reading time is basically 0 right now. Agrilith says, first time super chat, long time fan. Oh, hey, what's up, Agrilith? Your thoughts on Dick Masterson's Quickville Bella is the hero. We need hot take. That ratio. I have not watched his video. But I'm glad that he did the interview with her because it needed to happen. So, but no, I haven't watched it, so I can't give you a hot take. But yeah, the Kiwi Farms is not happy about that. Bad Vibe says Arnold is a fucking coward, and Twitter thinks so too. They are protecting him from me.
That Arnold quote was so disappointing. The man basically built his
your
life.
Freedom.
He built his life on the libertarian possibilities of America. The ability to do what you want, when you want, how you want. The freedom to do different things at different times. And for him not to be able to appreciate that is, more than a little bit disturbing.
Well, look, there was a crisis, right? There was a crisis, just like in 1930s Germany, there was a crisis.
Yeah.
That's his dad helped deal with the crisis in Germany. And did you hear about that, by the way? Turns out his dad was an SS.
I didn't know that in particular, no.
I didn't either until recently. So yeah.
I'm not going to hold his father's sins against him. I'll hold his sins against him. How about that?
Right. No. I'm not holding his father's sins against him. It's just funny that well, you're free until there's something wrong. Then we got to fix it. Whoa. Wait, the quartering. I am not fat, good sir. How dare you?
Was the quartering in here?
Yeah, he's in here. Oh. He's in here. He was in here the other day shitting all over Minnesota sports teams as if they don't deserve it. Of course they deserve it.
I just like to say to the quartering that, I do like your content and I do appreciate it. I like your style and, good job on, the million subs. You're doing something right. So teach the rest of us how to succeed, That's all I want.
Well, this motherfucker's work ethic is the problem. He's dumping out videos all day, and they've all got like these cool thumbnails and good editing and all this.
I cannot do thumbnails. I don't have that skill set, so that is a problem. But I do put out like video every day, so at least one. So anyways,
you got to get on Jeremy's level. You got to get out like 7. Andrew, let's see. Andrew War Snowboard says, you have a law degree and an undergrad from the University of Minnesota Southwest in Marshall, Minnesota. Does this mean, well, it's not U of M Southwest. It was Southwest State University. Does this mean that you have a degree in martial law? Yes. Othamer says, hey, Uncivil and Ricada, what do you make of the not 1, not 2, but 3 Hunter Biden laptops and the recent Hunter Biden video? It seems to be getting so little media attention. Look, someone sent me a picture of a naked Hunter Biden, and thank God the crotch area was digitaled out, right? Like a censored anime or whatever. It was, God, it was disgusting. And I was like, well, I don't want to see this.
It doesn't surprise me that in any way the stories that we seem to cover and how we cover them seem very based on party designation. Even in like the Cuomo resignation, the way the media has been covering it, it's like begrudgingly and still talking about the fact he might have a political future and such and so on. So yeah.
Yeah, that I meant to do a short video on him resigning in 14 days. Just 14 days to flatten the administration.
Yeah, 14 days to flatten the curve. Yeah. Will it be like the previous 14 days to flatten the curve? Probably, if I had to be a betting man.
The denialist says, here we are, Nick's late and gay, chat's a fat mad about it, and all we got is an AI that thinks it's uncivil law to distract us from this. Okay, That's a good enough start. Let's jump into. Oh wait, no, sorry, two more. James Karg says, super happy Texan right here. Our Senate finally got the direly needed election bill passed today, despite a 15-hour filibuster that basically stalled the inevitable. Yellow Rose of Texas intensifies. Yep, that's true. The Senate passed the election bill. Has the House reached quorum and voted on it yet?
I don't think so.
So that's the next step. They had the warrants issued.
Yeah, it's like, yeah. Can those warrants not be enforced across state lines? Is because it's a valid warrant, can't the full faith and credit clause kick in or something at this point? Arrest them no matter where they are?
I think it can, but the question is, will you get DC police to comply with it? Like, what are they going to do? Mandamus the police department?
Yeah,
in Washington?
Yeah, it'll be fun.
That would be fun. Yeah, and Paxton's just crazy enough to try it. So maybe. Automata says, Nick, did you miss that the motion where the government said they have Brady material was them arguing they need to have extra time not counted in the speedy trial rules because it's taking a long time to hand it out? No, I wasn't really concerned about what was in the motion other than a discussion of the potential that they'll be withholding exculpatory evidence. The problem is they're developing these discovery files that are so big that it's possible that they're going to miss something. And the Brady rule doesn't allow you, it doesn't allow there is no harmless error. There's no accidental or unintentional failure to disclose that is allowed because the government. This is one of the few rules that are really, really pretty strict on the disclosure. Now, there's a lot of argument around whether the material is relevant and whether it's actually exculpatory. But if it is, the Brady rule kicks in, whether they intended to or not, and that's great. So combine that with speedy trial. And if their excuse is they want to comply with the Brady rule, but it's taking so long, it's like, yeah, sorry, that's your job, though.
It's a bit of a self-created problem by compacting all these cases at once because the statute of limitations is 5 years to the best of my knowledge. So they don't need to necessarily bring all these cases at the same time. So it's a bit of a self-created problem on that one.
Yeah, so it's I have no sympathy for the prosecutors in this case. They need to, it's their job to do it this way, or to do it appropriately. And this is a fundamental due process right that's in question. And that's the right to have all of the evidence that the government has at their disposal at yours. They don't get to take government surveillance footage off of the table just because they're the government. So,
I mean, fundamentally, it's just that everyone should have access to the same evidence. Everyone should have access to the same witnesses. Everyone should have access to the same information.
Right.
And so neither side is surprised we don't do the trial by ambush thing. Every side has the available evidence so they can argue from it accordingly. And I'm not sure that they need to cheat necessarily because you're in D.C., so one would think you're getting a pretty favorable jury pool. So since D.C. voted, 91% or something Democratic? So, yeah. So I don't think you have to cheat on top of it.
Right. Not having to cheat being the prosecution, you're saying.
Yes.
Yeah. No, I agree. It's weird that they might, but the cheating could also be inadvertent. And that inadvertent cheating could still prejudice a defendant and then they win. And that's just interesting to me that could be here. Okay, finally, Ass Crush'em says first time super chatter. Yes, you are, because I would remember that name. Thank you. Thanks for entertaining me throughout work. Here's some shekels. Cigar recommendations. Oh, I am not good at cigar recommendations. I have not encountered a cigar I didn't like.
My go-to for entry is always Macanudo. I think that's a good place to start.
Okay.
It's a fine cigar in its own right. So if you're looking to start cigar, I think the Macanudo is a really good choice.
If you're really girly, like Vic, for example, you could have a Cuba acid cigar, and they're really tasty and delicious. The exact opposite of what a cigar should be, in my opinion. But they're sweet and they're good. So if you like sweeter things, that's a fine cigar to have. Okay, let's talk about the critical case.
Yes.
Can we do that?
We can.
Okay. How should we do this? So this is a weird situation that only exists because true crime podcasts exist, right? Like, I think that's fair.
Yeah, I mean, in part, there's ways to do it better and ways to do it worse. I think it's just because critical K, and maybe it's not such a true crime thing as such, as it's just critical K and how she presents information.
Yeah, but I mean the situation in general. So the backstory of Critical K. If you guys are not aware, let me run through the drama very briefly associated with this channel that links to Critical K. All right. So when I started covering the Sophie Long case, it was in response to a group of people who were very mad at Kiwi Farms' Ken Jennings for covering the case on his channel. And he ended up being doxxed, and he ended up being fired from his job as a result of the lies of some of these people. And this one Lisa person, I think in particular, who is not the Critical K. However, in the aftermath of what happened, several of the people who were in Ken's, who were yelling at Ken in his chat and all of that stuff, did end up getting doxxed by the Kiwi Farms. I think mostly by Spectre. And one of those people was the Critical K, Karen Yax. And yes, she's Karen, and her last name is a herd of large animals.
Yes.
So she is the Critical K. This case is not related to that at all, but it's just this weird overlap because, again, I was accurate when I predicted that all the people mad about the Sophie Long case were actually a bunch of, cat hoarding true crime ladies. That's just how it turned out to be. But so the Critical K, though, is being sued over a completely different situation, which is a true crime podcast type discussion going on. And it's about this case in Mississippi from 2014. And the case involves this young man who, there's some weird circumstances around it. Long story short, he went out with a friend. That friend was with him and then wasn't with him, but was at his bank trying to withdraw all of the money from his bank account. And then he ended up dead. Mm-hmm. In his apartment, slumped over a bathtub. And the chief of police, who happened to live in the same apartment building, walked up there and ruled it a suicide. It was a bullet to the right side of the head. The gun was wedged between the left side of his body and the bathtub. It kind of seems like the body was probably moved. So who knows but it was ruled a suicide. But there's some contention around that ruling, particularly coming from the young man's mother. All right. Mm-hmm. So the young man's mother is a psychiatrist or psychologist. Do you remember?
I think it's a psychiatrist. I think she's a nurse psychiatrist, though.
Okay, so she's some level of psychiatrist or nurse psychiatrist or something in Mississippi. And since this happened, she has been trying to basically find some sort of justice for her son, who she believes was murdered. And like I said, it's been ruled a suicide. Now, in the coverage of this very this is kind of a contentious true crime thing because of the people disagreeing over suicide and homicide. In the coverage of it, the Critical K made some statements that the mom claims are defamatory, particularly around bribery, around allegations that she may have contributed to the self-harm and suicide of this person and another person. So does that accurately sum up?
And also that she might have given alcohol to minors. Yeah.
Right.
So there's these very specific fact statements about she did these things. She contributed to the death through negligence of a different patient. She's tried to bribe people. She's tried to, basically acted in a corrupt way. So that's the lawsuit, basically suing over those fact statements.
Yeah, and so this case was kind of on my radar because people were like, "Oh, this person involved in this thing is also being sued," and I was like, "Oh, that's neat," but I didn't really look at it. Mm-hmm. And then I finally looked at it the other day, and I realized that I happen to know the plaintiff's attorney a little bit. Not like we're not like best friends or anything, but I've talked to him before. Seems like a nice guy. gets involved in some pretty interesting cases. And so it was like, oh, well, now
he's
I
out
have
of
to talk about it.
Mississippi, that guy, right?
Yes.
Yeah,
Yes.
what I found really interesting when I was reviewing the case is he is an admission as a lawyer to the USPTO, which means that he's a patent lawyer, which I thought was
Yeah.
really cool. So I'm like, hey, brothers in arms, man. Patent lawyers
He,
want to do something else.
he's also admitted in Tennessee as well.
Yes.
And so yeah, he's an interesting guy, very very smart, and has kind of he's got a good writing style, I think. And so he's got this case where they're suing for defamation, and it's a little bit weird though, because my first thing that I noticed in this case is jurisdiction issue, right? Like, because critical K is in Michigan and this case is in Mississippi, or is brought in Mississippi in federal court. So you've got to get jurisdiction over this lady down in Mississippi. And it's I think it's a really tough question, actually.
Well, there was some suggestions that there might be things that might lend more credence to the idea, but they weren't in the complaint, at least. That she might have done more specific things with respect to Mississippi and more specific whatever. But yeah, basically the way it was pled out made it look a lot like the Toddy Westbrook without a crystal ball case. And like,
Right.
they look very similar. It's like, okay, in this case, Karen is producing videos in Michigan. She's putting them on YouTube. She's running a blog. She's not particularly targeting them anywhere. These things are mostly passive, to the extent that she's adding to it. It would be the same like YouTube, making comments or responding to comments or stuff, but it's mostly a passive experience. People have to request the content, and it was kind of the same situation in Crystal Ball's case. And so in both cases, you're coming to the same kind of idea. Okay, maybe there's not enough specific things here, or at least that haven't been stated. Of course,
And
it would have been nice if Critical K had been able to argue any of that, anything approaching a lucid idea, but
well, and in cases like this, that's the position you and I want to be true, right?
Yep.
Because we cover stuff that happens all over the country, and I don't want to be hauled into court in some state 1,000 miles away because I put out a YouTube video and someone got pissed off, and neither do you.
Yeah, I covered cases from all over the world and
Right.
all over the U.S. And so I was like, if you take, this was ultimately the problem, and I identified this problem, I think, in the very first video I did on the Toddy matters. Like, if you take what Toddy is arguing as true, it implies jurisdiction everywhere. And that can't possibly be true, because that leads to a complete nightmare. So, yeah.
Although, side question, and you were kind of touching on this in your Critical K video that you did today. So I wanted that. Oh, I never got to. Yeah. So Kurt was doing a Critical K video today, and I was like, oh, I wanted to talk about this. So that's what sparked me to actually call you up and say, hey, we should do this, or text you or whatever it was. I can't remember. But yeah. So the Critical K incident is what sparked this video. But so here's the hypothetical. You mentioned how like all of like the hiring of lawyers and stuff is happening virtually now. You've got Zoom courts, so early appearances probably don't need to be made. Do you think we'll get to a time where there is jurisdiction anywhere because appearance anywhere is it's irrelevant, right? Like,
That's actually a reasonable question. I hadn't really thought about it that way. But yeah, you might. That's a reasonable question, because especially compared to when International Shoe was written, which was what, like 1940s or something.
it might have been earlier even.
Yeah, air travel was in its infancy. Getting from place to place is very difficult, and the methods of communication are very, very slow. And now that you have the ability to basically get on a camera and appear anywhere, and you could do entire depositions virtually. You could do, so maybe you still need to be there for the court hearing or the trial. That might be a little bit difficult to do virtually. But other than that, you could probably do everything on camera if you really had to. So yeah, maybe International Shoe and we'll have to be reconsidered in light of modern technology. Yeah,
God,
I thought
what
about
a
it.
disaster. It'd probably be more efficient to not spend a year fighting over jurisdiction issues in federal court for all of these cases. But at the same time, I mean, there's other implications to that because you have different law that you're operating under. Like if I'm talking, I go, okay, I can research Minnesota laws and be reasonably confident that if I get brought in for a lawsuit, it's going to be applying Minnesota law.
Hmm.
Um, and now, with that possibility, that may not be true. That'd be a mess.
Yeah, but other than the possibility of Louisiana, which technically is under a civil law system, I think that you and I, if we had to in a pinch, could pick up the statute books of anything else and do the case law research there too. I'm not, because you have enough baseline knowledge to be able to work from. So
Right. Right.
this was one of
Yeah.
my
And that,
things with the federal system and how they deal with court admissions, because I always felt like it wasn't really fair because, first of all, you're dealing with federal law, not state law, so you should be admitted to the state to the extent that you're incorporating state law issues because of, bringing it along with the federal cause of action. Any competent lawyer should be able to look it up and be able to do it. So I don't really like the way the federal courts do admissions. I want to be admitted to all the federal courts. That'd be great.
start sending out a bunch of letters.
Well, when I was sworn in at my state, and I know when you were sworn in at your state, we both were admitted statewide, right?
Yeah.
So, like, why am I not admitted federal wide? Like, I was admitted statewide. Why is that not a thing?
The only thing I can think of is racism.
That does seem to be the answer for everything these days. So, sure, let's go with racism.
Okay. So now the questions I did have some questions about jurisdiction for you. Now I know so Critical K is representing herself to the chat. I don't want to pull up her pleadings. I kind of just want to have a discussion around it because pulling up the pleadings, we can get into the weeds on some stuff. Long story short, she's representing herself. She's not really competent to do so, and she really should hire an attorney. Like that is what she should do. She should bite the bullet and hire an attorney. Otherwise, she could end up in some real trouble on this case, mainly because of unforced errors on her part. But so I was trying to explore this jurisdiction question, and figure out, is there something interesting? Because in Matt's pleadings, there were some indications that the Fifth Circuit may allow for jurisdiction in this case, based on some cases that he cited. And one of the theories is like this idea that while so it requires purposeful availment of the forum, right? That's the language. But on some of the shows where she made some of the statements, she actually was contacting and interviewing someone within the forum. Right. Mm-hmm. So she's making these statements, and she's in the same video, she is contacting someone in Mississippi, knowingly in Mississippi, because like that's her intent. I need to contact this person from the area to talk about this case. So does that, in your opinion, does that lend an argument towards purposeful availment at that point?
It would depend based on other conduct in other cases, in my mind. So one of the things that the judge in the Toddy Without a Crystal Ball case pointed out was, unlike Calder, which dealt with the National Enquirer and had produced a story concerning California and conducted an interview in California to further that, and sent 600,000 copies of the National Enquirer into California. Right. That in the Without a Crystal Ball case, she didn't call into anyone in Washington for a source. But I took the position in my analysis in the motion, and when the case was actually dismissed, that just because there is a source in Washington might not be enough, because maybe it's just another path or another stop along the random journey like it is everywhere else, right? One of the things that was argued in that case was she pulled court records from Washington. So she's purposely availed herself. And the court noted, yeah, but she's also pulled records from Hawaii, North Carolina, South Carolina, blah, blah, blah. And yeah, so it's just a stop along the way. There's nothing special about it. So if she had called someone specifically in Washington, to my mind at least, it would be the same question. Is this like special, or is this just another step along the path? So to answer that question, you have to look to how she handles other things. And, to the extent that she focuses more on Mississippi and calls more in Mississippi, that could be a thing. So it depends how discreet it is.
what I was thinking was, and I don't know if this is true, but what might be a nail in the coffin on jurisdiction there would be if she contacted someone in Mississippi and made defamatory statements to that person in Mississippi. That would be I think that's where you got them on that one. Like that's got to be it. Because
in that case, you're committing the tort in Mississippi. You're there,
right?
And if you're there for even one purpose, right? That's the thing. Like if you have personal jurisdiction for anything, then the court has jurisdiction over you for everything.
Right.
So yeah, if you can find one thing they have jurisdiction on, it's game over.
Yeah, and I think that's going to be the issue is can they show something on that if this gets contested, right? Like the judge I don't know that they will because they're pro se, but the judge in theory could say that critical case pleading is inadequate and she's not sufficiently alleging a lack of personal jurisdiction. Because what she basically did was throw up a spam of citations, but like you said, she doesn't really apply fact to law and talk about why those citations matter. So, as you mentioned, if she gets a judge in a bad mood, then they're not feeling charitable. They're like, we're not going to do your work for you. You're pro se. You have an obligation to conduct yourself appropriately.
At least she had ideas that made sense. That was a vast improvement from her so-called answer, where she didn't have any ideas that made any sense. It's like, oh, I was relying on things in the public record. What things? The public record. Where's that?
All of the things. all of the public.
Okay. It's that's not really going to work. Yeah.
Her answer is also kind of a problem because it does. I mean, she sort of asserts that the court may not have jurisdiction. She at least raises the issue, which is good because she could have accidentally waived it if she hadn't raised it in her answer and answered before filing her motion to dismiss. I think that's although the court has a duty to raise that issue sua sponte, don't they?
For jurisdiction, for personal jurisdiction?
Yeah, don't they?
No, I don't think so. I almost surely not. For subject matter jurisdiction, yes.
Okay,
but not
so
for personal jurisdiction.
I'm thinking of subject matter jurisdiction then. Okay, gotcha. So she does raise it, but her complaint gets into like they're not great, but she's making arguments on law. Like so, it's like wait, but if they don't have jurisdiction, you're kind of expanding your appearance here. But I don't think a judge would be too harsh on her for that.
No, that's fine. If actually. I don't know how this plays out on a technical level because she's technically made an answer. And so, technically speaking, she may have waived the personal jurisdiction issue by making the answer.
Yeah,
that's a problem. You see, once you start talking about the merits, you're done on jurisdiction because you've talked about the merits. And that's what the answer is for, is to talk about the merits. Now, I'm not 100% sure she actually did talk about the merits in the answer. I'd have to go reread it, but if memory serves correctly, I'm not sure she actually did address the merits because of how horrible it was. But, she did label in an answer, and the court could very easily look at that and be like, oh, you've just totally waived the personal jurisdiction. Sucks to be you. This is one of the good reasons that you might want an attorney. So, yeah, I don't think filing the motion to dismiss for personal jurisdiction is a problem on like doing too much in the court, but that answer, I think the other attorney might be like, that issue's over now, and so congratulations, this is in Mississippi, so
this is the only thing that may save her on that is that she does raise the issue. Is a matter of law which will be determined by the courts of the United States of America under due process of law. However, the defendant respectfully asks his complaint be dismissed based on lack of personal jurisdiction.
She did mention it in the answer. I don't know how that works. I guess if the judge is feeling really generous that day, they might give him a bye. But, if the other lawyer comes back and be like, this is an answer, and once you've answered the merits and you said, well, as to all this stuff, it's in the public record. That's a factual argument. I mean, you didn't actually attach anything that's from the public record, so, the judge could, I guess, technically, this is what makes so much fun. Like, her own screw-ups might save her. So, like, the fact that she didn't attach anything is like, well, that was just, it's just part of a motion dismissed. Poorly labeled. So, it depends how generous the judge is feeling that day, but yeah.
I haven't seen meretricious in a...
No, that was a new one. I had to look it up. I had to look it up. I'm not familiar with that word. I like that from Critical K. I'm like, okay, new vocab word for us.
Meretricious and utterly without merit, in line with several other cases that have been brought by the plaintiff against a variety of defendants merely to harass said defendants as part of a pattern of behavior that has been established by the plaintiff to bully, cajole, threaten, and ruin the reputation and or finances of all those whom she perceives to be enemies opposed to her agenda, to deny the official determination of suicide and the tragic death of her son, Christian Andracchio, by a self-inflicted bullet wound on February 26, 2014. She's getting into it. She's getting into it there. But
yeah, so I'm not sure about this one, but yeah. I don't know how I'd rule on this as a judge, to be honest.
It's a tough one because you have a dual problem. You have a duty or in a pro se case, a pro se litigant has the same obligations to follow the rules that literally everybody else does.
Yeah.
That's the pitfall of it. But courts are basically instructed to construe all of their filings liberally to compensate for the fact that they're untrained.
Yeah, so depending on how liberally I want to construe that answer, yeah. Maybe it's just another part of a motion to dismiss and something.
Yeah. it's a tough one. So, okay, so your initial assessment of this was that she has a 99% chance of losing.
The answer was a total disaster. It was an absolute disaster. It just says things in a very conclusory way.
Yeah.
It's like, I wasn't wrong because of public record. These statements are okay because public record. I'm like, how am I as a judge supposed to assess the non-evidence? Because, I don't do, what I don't do as a judge is go look. What you see is you provide me evidence. And then I consider that. I don't go look for evidence. So it's like, what exactly are you wanting me to do here? It's like,
Yeah, this is an interesting one because, this line, number 13, says the defendant asserts that the plaintiff's wish to bribe and get a minor drunk in order to further her ill-advised agenda is fully evidenced and documented in the public domain. Well, that's a fact question.
What does that mean? What is this public domain? What is that? What is there a thing called public domain? How can I find it? Where is it located? Which part of it would you like me to look to? It's a little bit like saying, oh, it's in the library. And it's like, I'm going to need you to narrow that down.
Right. And the thing is, unless there's a public record of her being convicted of bribery and giving alcohol to minors, then it being in the public domain that becomes a fact question on the truthfulness of the issue that you've of the per se defamation that you've asserted, like that.
In part, but you could also say, depending on how well it's documented in the public domain, then the issue would become either negligence or recklessness or knowingness, as the case may be. And my argument would basically be, I don't really need to know so you could either go with truth, which always is helpful, or in the alternative, you say, well, look, here's, 3 sources that have said this. It was reasonable for me to rely on these sources because of the places that they were published. And so that's what I reported on. And, and I didn't see anything contrary in these sources or other sources that I saw. So I relied on that, and therefore I can't be negligent. So, yeah, I mean, that would work. So in that case, actually, it's also nice because offering the newspaper articles and stuff is not hearsay, because you're not offering it for its truth, right? You're not saying that what this newspaper said is true, right? That would make it hearsay. You're saying this is what the newspaper said. I relied on it, true or not. I relied on it, and I saw it from a couple places, so I reached a conclusion it was collectively reliable. Like, a good journalist, I consulted my 3 sources and made a report. So yeah,
counter.
so no hearsay problems.
counter argument for you. It's not 3 sources. It's 1 source, the public domain, where it is well documented.
You know, I was an editor in a law review, and I had the unfortunate pleasure of spending some quality time with the Blue Book. And the Blue Book has wonderful citations for everything, but I do not remember the citation for the public domain. Don't remember that one.
You missed that page. It was torn out. It was torn
Apparently I
out by
missed
your
it.
predecessor.
Apparently I missed that one, yeah, somehow. Okay.
Oh my gosh. So anyway, so this lawsuit's going. It's pretty interesting because I think the defendant has made it interesting by not being represented.
By being incompetent in the sense of legally. I mean, she admits to as much in her motion to dismiss. She says, you know, unlike counsel, I'm not a lawyer. I don't know what's going on. I'm like, yeah, you've kind of alerted yourself to the problem. So, you know, would you like to do anything about that?
Yeah. It's this is a weird one. But I think it's funny. It's the pitfalls of putting yourself out there publicly. Though.
I want to know how she figured out how to file a response at all. That's what I want to know.
She mailed it in.
She just mailed it to the courthouse?
Yeah. Did you not?
Yeah, that's right, because there was envelope on the record. You're right. I didn't actually pull the envelope, but yeah. So she just mailed it in to the clerk of court with the case number and said, here it is. Okay, yeah, that works.
Attention clerk's office, 501 East Court Street, Suite 2500, Jackson, Mississippi. Paid priority mail express, $26 to mail this filing.
Express mail is expensive, yeah. I've only
She must have been pressed on time.
One of the nice things about express mail is it delivers 365 days a year.
Yeah.
Federal holidays, anything, it delivers every day of the year. It's a nice way to send last minute Christmas gifts if you have to, because I don't know whether UPS or FedEx will necessarily deliver on Christmas Day, but the post office will if you send it express. They'll deliver on Christmas Day. How nice!
There is no way this is following the court's local rules on formatting.
No, but you know, I'll give them points that it's lucidly formatted and I can follow it, and it's not like making my eyes bug out. So, you know. Okay, it's workable. The formatting or lack thereof is not its principal problem.
What do you think about this motion to compel?
Oh yeah, I mean it's totally correct. So by local rule, which is binding on this as long as we're in this court, you know. So it is a vile rule. By local rule, apparently the attorneys have to meet 21 days before substantive issues. I'm not sure exactly why, but they are. So the attorney, as he puts in this thing, sent a very nice email to Critical K. This is an email that I thought was best practices. It was very nice, very professional. We're obligated to meet. Yeah, this is great. You know, dear Miss Yax, pursuant to the initial order, you and I must meet telephonically to have our conference. Per the order, we must occur over the phone. Here is the rule. I'll be out of office tomorrow, but feel free to meet on Wednesday, Thursday, Friday. Please let me know what's good for you. I mean, what's not to like about this email? It's perfect. It's best practices. It's even kind.
Yeah, it's not snarky or
no. It's very, very nice.
Anything.
And so that apparently is the local rule. And then the first sentence of Critical K's response is where I put my hand to my head and gave up all hope.
Yeah, this is good. So she says,
why don't you read the first sentence?
The Mississippi court procedure is irrelevant until there is a ruling that the state of Mississippi has jurisdiction in this matter, a matter which I am currently contesting. Wrong.
Wrong.
Wrong. That's wrong. That's a terrible argument.
Terrible argument, yeah. No, yeah, first of all, the state of Mississippi having jurisdiction isn't quite the right way to phrase this, since we're not in state court. Second of all, the rules are relevant as long as you're there.
Yeah.
You want to fight over jurisdiction? That's perfectly fine. But the rules bind you as long as you're there. There are rules for fighting jurisdiction. Amazingly enough.
I mean, by her statement here, she would suggest that she doesn't even have to file to fight jurisdiction because those court procedures are irrelevant. So How dare, like, you got nothing on me. I don't need to fight nothing. So in the longer term, I will require you to provide a detailed itemization of what economic damage has been done to your client. Who heard my program? So she's asking for discovery here, which is interesting.
Kind of. And I mean, she is entitled to that eventually, because when we're going to determine damages, we have to, So yeah, that evidence will be presented at some point.
Right, but the interesting thing to me is if you're arguing over jurisdiction, it's just not a good idea to put down discovery demands when you say you're not that the court process itself.
They did say in the longer term, so it's not present demand, so we'll give a pass.
Who had a positive view of Ray Andracchio beforehand and a negative view afterward. What economic damages have my words done to a psychiatric nurse with an appalling reputation, both personally and professionally, a reputation which existed years before I came along? Unless you can answer these questions persuasively, there is no case and no jurisdiction for the state of Mississippi. Those are separate issues there. I do not voluntarily enter the Mississippi court process. I challenge Mississippi jurisdiction. In addition to all of this, I've alerted the court to the threat made against my person by Chris Thompson, your client's brother, which this isn't really relevant to this case, but and associate within the Justice for Christian Facebook group. Chris Thompson stated, "She keep on and somebody going to change her name to Critical Care or drop her off at the train station, one of the two. Your flippant disregard of this and your close and lengthy association with the Justice for Christian Facebook group and the administrators are all reasons for me to feel uncomfortable and unsafe having a phone conversation with you at this time. Critical thinking plus civility equals winning."
Yeah, and then I made the comment that last sentence is probably true, and it'd be nice if she displayed either one. Yeah. And then I did like the attorney's response. It's like, I feel honored that you think that somehow I can cause a threat to you when I'm like 800 miles away. Somehow I'm going to pose a problem to you through the phone. So, yeah.
Yeah. And, yeah.
900 miles away. I'm sorry.
Again, Matt's like the nicest guy with like this nice little Mississippi accent, and he's a delight to talk to. It's like,
I sent him an email, asked him if he was hiring. He said he's a solo, so no. But I was like, okay, because I'm like, hey, we can be patent lawyers in arms fighting defamation cases. Sounds fun.
With respect, I cannot see how talking with me over the phone would make you feel unsafe, considering that your residence in Michigan is nearly 900 miles from my location in Mississippi. Do you really believe that I will reach my hands through the telephone to inflict upon you some sort of physical calamity? If you truly believe that, then I am sincerely flattered that you think so highly of my capabilities. But I digress. The reality, Miss Yaks, is that you are simply making excuses, and silly ones at that. Therefore, in good faith, I'm giving you one more chance to give me a day and time this week when we can discuss the boundaries of discovery. Is Wednesday, Thursday, or Friday good for you? I'm free all 3 days. If you refuse to cooperate with my request, then I will simply prepare the scheduling order to the advantage of my client and submit the same to the court. Then when we chat with the judge on August 27th, you can explain how your irrational fear of me and telephones was a valid cause to disregard the court's rule and order.
Fear of telephones is a recognized condition, I think. I think it has a name for it in the phobias.
These are my favorite two lines of the whole
points
thing.
To whoever knows what fear of phones is, right? Yeah.
Phonophobia?
No,
telephobia?
it can't be that simple. It's never that simple.
These are my favorite two lines of the whole letter, though. We are not playing games, Miss Yaks. Govern yourself accordingly. Good stuff. Well, this is an interesting lawsuit because, I'm sympathetic to the Critical K. I really am, because I am an online commentator and I don't want to be hauled into court across the country. The question is whether she will be. And at this point, it's not so obvious. I think there's some questions, but she has to adequately plead them out or fight against them. So it's the plaintiff's obligation to show jurisdiction, but all the plaintiff has to basically do is say, well, court has jurisdiction because of these things, which he's done. And so now it's her job to kind of provide a reason why the court doesn't have that. Right? I mean, that's where we're at.
Yeah, I think this And it could be a SLAPP, just, a strategic lawsuit against public participation. And we probably need some sort of federal anti-SLAPP law to, get us out of the
I
confusing
disagree.
mess. Okay.
I just disagree with SLAPP laws. I think 12b6 covers them well enough. Personally.
Yeah, I'm going to disagree with you on that one too.
I know we disagreed about this last time, I think.
Well, then we're consistent with our relative positions, I guess. That's nice.
Yeah. Yeah. Well, it's okay because mine's the correct one. So it's easy to be consistent with my correct position that anti-SLAPPs are redundant and unnecessary. But that being said, and if you disagree with me, I'll mute you. No, I'm just kidding, obviously. But no, so it could be a SLAPP. I don't know that it is or is not. Some of the statements she made are, because here's my problem with SLAPPs, right? I think it can be both and. I think you can have a strategic lawsuit against public participation, but that lawsuit can also have legal merit because, bribery, giving alcohol to minors, and then the statements about counseling people into self-harm.
Mm-hmm.
If those are truly stated and not true statements, they're defamation per se. But there may not be a lot of actual damage done to the person. Like I think oftentimes the damages part of defamation cases are way overblown. So it's like, okay, so some little podcast, 17,000 YouTube subscribers or whatever, says this thing. Does that damage this person? Like, does it actually? But it is, again, taking the statements as, or is taking the assertions as true. This would be per se defamatory and therefore should be entitled to relief from it, right?
Mm-hmm.
But I think it could also be a SLAPP because the damages are nominal. And so the SLAPP though would be like having the public statement and the clap back from the court is the remedy.
Yeah,
but that's
absolutely.
it's still a strategic remedy designed to get people to stop talking about it. So that's why I have problems with SLAPP in and of itself, because it's not frivolous, but it could still be a SLAPP. And so that's where I come down weirdly on the issue. And that's why I don't like it. If it has merit,
I like
think
anything that affords me more flexibility to say things.
Okay. So therefore you want extra procedural rules all the time then. Just pile them on because
When it comes to speech, yeah.
Okay.
I think
I mistook I thought you meant to say things as commentary on your show.
Well, I meant that too. When it comes
But
to
I meant
speech.
But I mean about other cases. So you want another procedural rule to talk about the procedural rule on your show. You know what I'm saying? Rather than
No, I have no idea what you're saying now. I'm totally lost.
You're talking about protecting your ability to speak as much as possible, right?
Right.
I'm talking about having additional court rules to generate content for your channel.
Okay.
That's how I initially heard that. I was like, "Oh, okay, gotcha."
No, I don't want to generate content. No, I don't care about that. I want to have the ability to speak. I think freedom of speech is a paramount value. I think freedom of speech is probably the most important right we have. I think it even trumps other First Amendment rights, because the nice thing about freedom of speech is if you didn't have those First Amendment rights, at least you have speech enough to complain about it. So that's, good. So I think speech is kind of the paramount value. And so I'm willing to go pretty far to protect those interests, not just from government action, but also from private action, because I'm concerned about people using false things to harass people, sometimes called lawfare. And when it is in the First Amendment domain in particular, and even more so when it's in the speech domain in particular, yeah, I think there should be actual protection. So 12b6 may be enough for everything else, but I think freedom of speech is special and deserves some special protection. So you and I can say things online and not have to be worried about being hauled in before every court in the land because someone was offended and sues us just for the hell of it. I want the attorney's fees. I want damages when they fuck up.
Yeah, and I think
I get where you're coming from, and I similarly value speech. I just think that SLAPP laws are so frequently unwieldy and unwielded appropriately that it bothers me, because I think it, rather than, when there is merit to a case, it so dramatically increases the cost of litigation, and it so dramatically decreases the success potential of a meritorious case that it bothers me. It bothers me because I feel like justice is denied to so many people through SLAPPs who have a valid case. And that's,
yeah, fair enough. So it's a balance like everything else, and so I don't fault you for your assessment, because you understand the issue and you're understanding what you're balancing, because there's no such thing as like a free lunch. There's good side and a bad side of everything.
a free lunch. Are we in Japan?
Shut up.
This is an anime channel.
I'm gonna exercise my freedom of speech by shutting up and glaring at you.
You don't have a freedom of silence and glaring. How dare you? I'm sorry. It was rude of me to call out your free lunch. It just made me laugh.
Yeah.
Okay. So where do you see this lawsuit going, though?
Where it's going right now is it's going to the plaintiff's favor, because the plaintiff actually has an attorney who can make the right arguments, unless the judge is feeling incredibly charitable. So I said it's somewhere between 80 and 85% for the plaintiff to win, and probably more like 85% for the plaintiff to win. So it was 99, so she's improved her odds to 85. But the judge could look at this and say, well, the answer completely throws out the jurisdiction issue, and there's no evidence here. So how about we get? I see a summary judgment motion in our near future. So yeah, it's not going well right now. So critical K goes down in flames is the more likely assessment. If the judge is feeling really nice, maybe they'll give him a break, but it's a lot of breaks.
Yeah, I agree with that at this point. I think, I think we'll get an indication at the hearing, because they are scheduled for a hearing on the matter, I believe.
I'm definitely going to be attending that one. That should be fun.
Yeah, and so there should be a hearing on the matter, and I think that's where you'll get a feel for how the judge is taking the pro se litigant, right? Like that.
I'll give 2-1 odds that critical K winds up in contempt.
But what sanction do you predict for the contempt order? Just like, I don't know if she's going to end up in contempt, because I think the judge will basically just say, no, like, listen, like, this matters. This really is real. You are under these rules. I get that you maybe didn't understand that, but you are.
Oh, I mean, not for what she's done up to now. I wasn't saying for what she's done up to now. I think she's going to open her big fat mouth at the conference and say something really stupid.
Oh, that would be good.
Yeah. No, I don't think for anything she's done now there's sanctions. I'm thinking that, the judge is going to say something like, I have jurisdiction, or this is a valid issue, and critical K is going to say something incredibly stupid and wind up, with a fine or something.
You know what? I think this is one of the most critical attorney skills that pro se litigants don't have. Be quiet. When the judge is talking to you, don't interrupt. Don't say anything ever. You sit there and yes, I know the judge is wrong. I know they're not listening to you. You take it and you wait for them to finish talking. And that's how you do things. You've got to wait and let the judge finish, because I've seen that a lot with pro se litigants. They try and step over the judge, and it's like, no, just shut up. Just shut up. Just shut up. Just shut up. Stop it.
Yeah. It is rule 1 of litigation. Don't piss off the judge.
Yeah, that's my favorite part of her letter.
Rule 1.
Her email that is now before the court is basically telling the court that they got no power over me. And the court, the reaction of a judge is typically to say, yes, I do. I don't know that they will in this case, but they have to overcome that natural human reaction of saying, whoa, I absolutely do have power over you. This is my court and you're in it. So Yeah, I do.
Start arguing about the fringes on the flag. Judges like that. I saw there was a pro se who got sent to psychiatric psychiatric order to see if they're sane to stand trial. I thought that was pretty hilarious. I hope that happens more often. You know.
Wait. There's a pro se litigant who tried to get a psychiatric.
No, the sovereign citizen. Citizen. And they sent him to. They said, "Yeah, you're so stupid. I'm going to send you off to be mentally evaluated as to whether or not you're competent." I thought that was pretty hilarious.
My favorite sovereign citizen in court is there's a guy. You can tell it's a Florida judge, I believe, and you can tell he's had this guy in before. And so he's like, "Am I speaking to so and so?" And he's like, "Well, it depends. Do you mean the individual or the corporation?" He's like, "Yes," whichever one it takes. And they go back and forth, and he ends up sentencing that guy to contempt for a very long time. And he's like, "Well, no, you're telling the corporation." He's like, "Yeah, but you're an agent of the corporation, so why don't you tell the corporation what I said?"
Where can I find the corporation? It's like, yeah. This is always it's like, okay, so you're the agent or you're the corporation or you're the whatever, or the vessel was the one I saw recently. And I made the wonderful joke where it's like, oh, so she's a boat. She's a boat. We're maritime law now.
I'm a vessel under Admiralty.
Yeah. I was like, okay, so as the boat, can you tell me where I can find the person? Do you have any ideas? Or whatever. And they also said, it said at one part of the thing, I'm part of We the People, and then later on said, as a religious matter, I do not consider myself to be a person. So how do you consider yourself to be one of the people then?
They consider themselves to be multiple of the persons, so they're the people. That's how they get around that.
Okay.
I am not a person. I am a people. Okay, so here's the ultimate questions for this case. And then we can move on. But what does each side have to do next? What do you think?
I think the plaintiff just has to laugh a lot, and the defense needs to get their shit together, or otherwise it's not going to end well. I again would recommend trying to hire an attorney. You can find one that maybe will be within your price range, but it's not going well for your stuff. And even if the judge is merciful to you, if you continue on this line, the judge's patience will expire. So yeah, I mean,
do you think the plaintiff should shore up the personal jurisdiction argument? Because you seem to indicate that you thought it might be lacking from the initial pleading.
It is on the burden. It is the burden of the plaintiff to prove jurisdiction, and so it was a little bit lacking because they didn't make the specific allegations about specific things she's done or the specific aspects. It was too broad. The problem is the response is so weak that, it's just like there's not personal jurisdiction because I say so. So if I'm just looking if I'm looking at it just as a judge based on the filings, which technically I'm supposed to do, then I mean, okay, the plaintiff, even though they don't have anything, they have more than the nothing you presented. So, it depends. And also, someone had suggested that there is more specific things in Mississippi. So, yeah, maybe shore it up a little bit if it needs to be shored up. But at the moment, I wouldn't be doing anything, to be quite honest. If I'm the plaintiff attorney. I guess you maybe prepare your file for oral argument and have some stuff, prepared for when the judge says, well, what about this? Maybe. But yeah, that's a tough one because jurisdiction in this case is really hard. It's my biggest holdup on it is at this point, do they have jurisdiction over someone in Michigan from Mississippi who doesn't appear to have stepped foot in Michigan or Mississippi, didn't seem to target it in the release of the videos because, right, we're releasing on YouTube. We don't have a way to. Oh, actually, I have an interesting question for you. Let's say I'm doing a video about a civil lawsuit against you, right, in Texas, and I tag my video location to your city in Texas. Is that
because that's
You
interesting.
talking about a hashtag?
No, I'm talking. So, when you upload a video, you can
Sure.
scroll down and you can actually add a filming location to the city. What there or not?
If you say your filming location is Austin, that might be enough.
Yeah, even if you're not in town, but you can do it because it will. I think it should, because it intentionally will drive local traffic to that content. Like, that's the idea. This is local to you. So that's part of YouTube's algorithm.
That might, if that's true, then that looks a lot like purposeful availment. So I think you're there.
Yeah, I wonder if she did that. Probably
That'd be really
not.
stupid.
Oh, then maybe she did. Well, that it's an interesting case, but I think the jurisdiction is a very big hurdle. I'm curious to see how the court takes it, because you never know how they're going to deal with a pro se litigant. You just don't. One guy used to just dismiss every lawsuit that Russell Greer filed, and then he got a different judge, and the lawsuit's just as ridiculous, and he's like, nah, this is good. We're going to go ahead and go with it. We'll go ahead and have I'm thinking of a different case, but
by the way, before we
litigant.
move on to other topics, I did see your video about the Dominion not being dismissed, and that doesn't surprise me in any way. Yeah, it looked solid on the complaint. I'm like, yeah, I didn't expect those to be dismissed. So
yeah, I remember you talking. I never went through the full complaint because it was so long. But I remember you talking about
a really good case. I mean, they just went on and on and on. I'm like, oh, I thought they had it for days. So yeah, it doesn't surprise me that they'll have to defend it.
Okay, so since you brought that up, the new sort of narrative or mantra about that is, well, now there's discovery. But I think what Dominion is going to do is demand sealing orders on pretty much everything as trade secrets.
Sure.
Because I think that's the move that they're going to make. They've suggested that they're trade secrets. What do you think about that? Do you think they have a good chance of getting it?
At least for some stuff, sure. I mean, anything, yeah, there's a wide latitude there for, yeah. So I don't know about everything, but a wild stuff, sure.
Yeah, I'm curious. On one hand, I mean, I think there's some trade secrets, but on the other hand, I kind of wonder, like, this is about an election, and the method of tabulation for the election. I don't know that should be a trade secret.
No, I don't think really it should be either. But that's a more higher level problem. Why are election boards are using closed source software and closed source black box machines as opposed to open source software where the code is open, at least? So it doesn't have to be open source in the sense of being free to use, but at least the code is available so people can inspect it and see what it has to say. The fact that they're using closed box software for elections is a little bit concerning, because the old software we used to have was, a pencil and a sheet of paper,
and someone going,
it was
1, 2, 3.
The old software was great. Yeah, people made a little mark, and people then checked it in the presence of other people to make sure they were counting it correctly. It was a wonderful system. So the new system, Yeah. I don't think there's anything fundamentally wrong with software, but the fact that I'm not able to validate that is annoying. But yeah, that would be the legislatures who've apparently decided they're completely okay with this, and the Board of Elections who think they're completely okay with this for some reason. Even though at DEF CON every year they have the hacking the voting machines thing, and it doesn't tend to end well for the voting machines.
It takes like a minute for them to, like, they get in over so they have an air gapped voting machine with with nothing open on it at all, and they like pull out their iPhone and they hack into it in like 5 to 10 minutes. It's like, oh, come on.
Then they got Doom playing on it, which is pretty great.
Can it doom? Okay, so that's that story. I thank you for walking through that with me. I wanted to go through it, but I saw you going through it, and I was like, oh my gosh, this will be much better if I have.
I know, because you're hearing it from a better lawyer, and so everyone's more well informed.
Exactly. That's what I was about to say. Hold on. Let me see what I can do to your freedom of speech. That was good. Welcome back.
Thank you.
Okay. So now we get to go on to a less jovial topic. And these are my favorite, less jovial topics, right? That's what we want. We want to talk about this stuff. Apparently. Because I don't want monetization, right? Like I don't want that in my life.
Apparently not.
Who would? Who would want to have things monetized?
It's not like it's your livelihood or anything.
That's true.
By covering this, you're taking food out of your children's mouth.
Well, that's okay. They eat too much.
I'm going to report you to CPS. How about that? That'll be good.
I don't think you'd be the first. I'm pretty sure various people on Twitter have tried. The funny thing is I answer the door for CPS with a gun. That's a joke, actually. No CPS people have ever come to my house. And if they did, I would tell them to come back with a warrant.
Exactly right. I mean, it's like, can I enter? No, you don't have a warrant. Yeah, it's like you.
But I have this police officer. Yeah, I don't care about that.
He can't enter either without a warrant.
Yeah. So, oh my gosh. We're going to talk about CPS later, so that's more fun. But first, for now, let's talk about this. Wisconsin judge to plead guilty to federal child pornography charges. Pending court approval, the judge's plea agreement would resolve cases in state and federal court accusing him of uploading child pornography more than 24 times using an online messaging app.
Which online messaging app does it specify?
Kik, K-I-K.
I'm not familiar with that one.
And to Kik's credit, they turned him in. Well, maybe that's to their credit. I don't know. I guess they were monitoring the conversation. But you have to assume that
if memory serves correctly, I don't believe that content is protected by the Section 530 or whatever it is, protections for safe harbor.
Yeah, I'm not familiar. I'm just thinking through the Fourth Amendment sort of stuff. Like this seems like you wouldn't even need a warrant to get this information because it'd be part of business records if they regularly keep them, if they regularly track, conversations. Because that's been one of the interesting arguments.
Yeah, Section 230. I don't know why I had a brain fart on that. Yeah, but Section 230, which makes the speaker not the publisher, or the publisher not the speaker, I believe doesn't exempts it with related to this kind of content. So Section 230 doesn't protect this kind of content. So as a result, they have an incentive to, get it off their platform and report it. Yeah.
And so, okay, so yeah, you're talking 230, and that's correct as far as I'm aware. I was going the other route of, how they procure this information. And I had an interesting sort of idea. When you're talking on Facebook Messenger, for example, and you talk about something in Facebook Messenger, suddenly you'll get a bunch of targeted ads for the thing you're talking about, right? Like, or if you have an Amazon Alexa in your house. By the way, Alexa, play Despacito. If you have one of those in your house and it's recording what you say, and Amazon, like you consent to Amazon or Google or Apple to store various phrases that you say so that they can improve their voice recognition software. So there's this interesting argument, I think, in regards to Fourth Amendment that, and I don't think this is appropriate, but I think it's the law, that law enforcement could get those records as business records that are maintained by a third party that you consented to without a warrant. What do you think about that?
I think it's right.
I think it's right too, and that's terrifying to me because I think it's wrong. But I hate that business records exemption. By the way, I think they should have to get a warrant. Like I don't think that the cop should be able to go to your bank and say, "Yeah, I think this guy is buying drugs. We want a record of every transaction he's done in the past 180 days because we think he's buying drugs." And the bank's like, "Yeah, here you go. Here's a list. Here's every check they've written." It's like, well, what about all the hookers you paid by check? Right?
I'm not sure that's a big factor.
Well, you want to keep them anonymous.
Isn't that's what cash is for?
But what if you didn't have cash and you had to pay by check? You got to keep the hose on the down lows.
Uh-huh.
So I just don't think it's fair that if the government says, all they have to do is say, we're looking for drug transactions, and then they get a bunch of check blanks to your hose, that they then get those without a warrant. That doesn't seem right to me.
Let's move on.
You carry too much cash on you, my friend. You got to have checks for these. Okay.
How many prostitutes checks have you written?
0. That's actually the funny part of it is I think I'm way wrong on the cost of prostitutes because I would never buy one. I think they're probably much cheaper than I think they are.
It depends on the prostitute, I'm sure.
That's what I'm saying. But okay, question to the chat. Just an open question. People can just drop a dollar amount and we'll all know what you're talking about. If you've ever purchased a hooker before, just go ahead and drop that dollar amount in the chat. I'm curious how much you spent. That'll be a good result. Okay, so here we go. Oh yeah, because I remember I saw a sting of a Navy guy and it was really cheap. 9,500, 165, $20, 2,500, 50 to 250. Oh God, it's so inexpensive. It makes me uncomfortable. 300, 150, 200. Damn, I don't know, man. That's see, I would be concerned. Okay, Milwaukee County Circuit Court judge charged in state and federal courts with multiple counts of possession of child pornography has agreed to plead guilty to the federal charges according to a plea agreement approved by prosecutors filed with the court on Wednesday. Under the arrangement, Brett Blum, 38, would plead guilty to 2 felony counts of child pornography possession, forego his right to a jury trial, and forfeit any property or assets connected to his crimes, which I believe is just his iPhone. Each count, and the grippy case that was on the iPhone. Each count carries a mandatory minimum 5-year prison sentence, 5 years of supervision, and up to a $250,000 fine. Damn. Criminal complaint was filed in March, in which he used the messaging app Kik to upload pictures of videos of child pornography on 27 separate occasions in October and November 2020. Then why is it just 2 counts? Under the username,
I love his username,
Dom Master BB.
Now, what could BB possibly stand for?
What should be shoved into his eyes?
No, what is his name again?
Brett Blum.
Yeah.
Yeah. Well, it could also stand for BB as in baby, like Dom Master Baby, because BB that's an online truncation of baby is BB.
Okay.
Or BBY on occasion. Not like a baby.
Oh,
right?
and he registered using his personal Gmail address. Oh, that's a nice touch.
Yep. Oh yeah, they they got him. After Kik and the National Center for Missing and Exploited Children tipped off agents with the Wisconsin Department of Justice in February, an investigation led by the state's DOJ's Division of Criminal Investigation connected transactions of child pornography to multiple other email address, phone numbers, and IP addresses, including those at Blum and his husband's home in Cottage Grove, the Milwaukee home of Blum's friend, and a Milwaukee County government building. So he was doing it at work, is the implication there, is my thought. So he gets out his phone. Blum was arrested at his home in the Madison suburb in mid-March and charged in state court with 7 felony counts, each of which carries mandatory minimum of 3 years initial confinement and up to $100,000 fines of imprisonment. He is currently incarcerated in the Sauk County Jail in Baraboo, according to court records. The judge was indicted in federal court in May. So he was originally counted 7 counts with 3-year mandatory minimums, but then they moved them up to federal court with 5-year mandatory minimums.
Have we not considered a VPN? Since we're getting it back to his IP addresses.
Yeah,
This is
Yeah.
this would be a good place for a note from our sponsor, NordVPN.
And if you're uploading questionable images, brought to you by NordVPN, be safe and secure in your uploads. Can't be tracked by the feds or anyone else. Nord. I'm just kidding. I'm not sponsored by Nord. I'm not. I think they reached out to me a while back. I should probably go get it and do an exclusive video on this. What do you think? Do you think they'd cancel my contract immediately?
I think they might have some objections to that, yes.
Just throw that in there. Little 3-minute. What you do is you do a 3-minute video about the issue and then a 5-minute NordVPN ad. Right? And then you've got your 8-minute video. It's perfect. Okay.
Yeah.
The plea agreement, the agreement acknowledges that he used his iPhone to distribute sexually explicit images of children on the Kick app, as described in the indictment. The plea agreement, which resolves all federal and state charges, does not include any discussion of sentencing or restitution. Now, I don't do federal criminal practice. In your coverage of federal criminal stuff, do you see that? Because I tend to see this, that the federal plea agreements don't actually discuss sentencing.
They can go both ways. I've definitely seen sentencing included in the plea agreements. I've seen it left open, so it's not uncommon either way.
Okay, in
if
the
memory
plea
serves
agreement
correctly, I'm pretty sure that the Fogel plea agreement included some explicit plea term agreements.
Gotcha. I was just thinking about my experience in Minnesota criminal court. Sentencing is it's at least discussed in the plea agreement every time. So I wasn't sure on federal stuff. In a phone interview on Wednesday, let's see. Van Wagner emphasized that his client, quote, has signed a plea letter because he intends to plead guilty in the interest of admitting his guilt and resolving the matter as soon as possible, adding that he and his client would have it known that nobody is as bad as their worst decision, nor as good as their best success. What do you think about that statement? Because I think,
yeah. What is that comment? What is that sort of old joke? You know, you build 1,000 bridges. They call you a bridge builder, but you fuck one goat.
Okay, that was good. That was good. My question, okay, so I'm willing to accept this premise. Nobody as bad as their worst decision. But what about their 27 worst decisions? That's the question I have for Mr. Blom. You might not be as bad as your one decision, but what about your 27 of them? And the thing with this is, it was more, right? Like in these cases, it's always more than they charge out.
Yeah, it's pretty axiomatic that they never catch anyone for the first crime.
Yeah,
I remember a discussion I had with lawyers from the SEC once, because you go to different bar associations and run into people. I was asking him, I was like, "Have you ever caught anyone for their first thing?" And they're like, "No." And we never caught anyone for their first thing. They always start off small, get a little bit bigger, a little bit bolder, and some point someone notices and then tracks back for all the things that they've done. It's never the first thing that gets them. If there's ever been someone who's done the one and done, we haven't found it. So yeah. So you can reasonably be assured that 27 is not the total number of videos he's uploaded. It's also the same thing that's a little bit frustrating when it comes to DUIs, right? So you see these people with 5 or 10 DUIs who apparently are still able to drive somehow, and you're like, yeah, we all know you didn't commit only 10 DUIs. We know the real number is quite a bit higher, substantially.
Or you could be like famed Michigan super lawyer Kevin Landau and lose your license forever after only 2.
I don't know how that happens in other states. They seem to get away with it forever. If anyone can explain the logic of that, yeah.
Well, I think Kevin might have had bad representation in the matter, but it was his dad was representing him, by the way.
Not the best choice.
No, it was not good.
Look, he used mouthwash. It's like, sir, why do you fail the rolling breathalyzer? He's drinking scope while he drives. Don't you guys do that? Blum was elected to the bench in 2020 after defeating incumbent Judge Paul Dadinsky, an appointee of former Republican Governor Scott Walker. After taking office last August, Blum worked in children's court at the Vel R. Phillips Juvenile Justice Center in the Milwaukee suburb of Wauwatosa. He previously served on Milwaukee's Board of Zoning Appeals upon appointment by Milwaukee Mayor Tom Barrett, who also backed Blum in his recent judicial election. Blum was formerly the president and CEO of the Cream City Foundation, a local organization that mobilizes philanthropy to provide scholarships and other resources for the LGBTQ plus community. And it's important to note that
Why is it called Cream?
I don't know. But it is important to note
Doesn't that sound like a weird name to go with LGBTQ? Cream. I mean, it's suggestive.
It could be suggestive, but it could also be related to the city they're in. I'm trying to.
Is Milwaukee known for cream?
Why is Milwaukee called the Cream City? Okay, so yes, Milwaukee is called the Cream City. So that's
why?
Let's see, because of the yellow. Wait, God damn it. Yellow cream-colored bricks that were first discovered and made here in the 19th century. The bricks were used for many buildings and businesses, breweries, schools throughout the 19th century.
Okay. All right.
It's the beige patterning of the buildings, the old buildings, I guess.
Okay. Noted.
So that's the excuse that they have anyway. So it's important to remember that the Cream City Foundation, it was in the news. They were providing drag queens to read stories to children at libraries, and there was a public uproar over it because for some reason, and I don't know why this is, because this doesn't make sense to me, but it seems to happen that some of these particular organizations don't just passively do something, right? Like, it's not just like a drag queen goes and reads a book somewhere. There's always got to be some like push with it. Like there's like trying to get more kids to the Pride Parade to destigmatize kink and stuff like that. It's like, look, I don't want my kids to have destigmatized kink from the hetero parade. Like, I don't want any of that to me. But that's, yeah, it's kind of a weird thing. And of course there were allegations of inappropriate behavior at these things as well. So it's, yeah. What do you think? Children juvenile court judge, shows up.
The only way it could get any more disturbing is if some of the CP he was uploading was from cases that he had. That's the only way this could get any worse.
That would be particularly awful. That's the thing about these cases that's hard to cover them because you don't want to see it, but you want to know, like, and they have so much interest in protecting like the identities and stuff like that they don't ever release the information. But you want to know if that was like part of it, because you want to know if this guy should go to jail or be like thrown off a building or something, right? Like, because that
both.
It's, both and but that's yeah, this is just crazy to me again that this. So I'm covering the Sophie Long case, and we don't need to get into it, but there's lots of conspiracy allegations about like child trafficking and stuff like that, right? And so people ask me, they're like, what do you think about those? I'm like, well, I don't know, because I don't have evidence of it. Like in this case, I don't have any evidence that the judge did what you hypothetically proposed, right? It would be worse if he were like taking pictures from a court file that he had and uploading them secretly. That would be particularly appalling. And in the same way, like with the Sophie case, there's allegations that, well, they stumbled into a trafficking ring basically, and that's why there's all this stuff leveraged against them. I have no information about that, but someone was asking me, and I'm like, so while I don't know though, we have been finding this stuff cropping up like in places where it shouldn't happen, right? A juvenile court judge should not ever, like, there should never be a conviction, even an accusation of child pornography. Like that should not be a thing. And, and I go back to U.S. gymnastics, right? And Larry Nassar. It's like, this is the one place. These are the top level athletes. They're supposed to have the highest level of care and supervision, and fostering to be competing at such a young age at the peak level. And then here we go. We have this guy doing this constantly. And then you go to like Penn State and you have a similar sort of thing where there's Penn State is where, these kids who are visiting should be safe. Turns out they're not so safe. And then there's cover-ups going on. So I never know what to think about this, the conspiracy angle of these things.
I don't really understand what you mean by conspiracy angle though.
Well, like just... Okay, so the conspiracy theory of like the Sophie Long case would be this lawsuit has been so crazy because she was basically the target of a moneyed and protected child trafficking ring.
I don't know about that. As I said before in my channel as well, I don't really like family law on a pretty fundamental level, just because I find it very difficult, at least reading cold records, to try to figure out what's true. Because I don't know if there's any method, and maybe someone else has a better sense of it. But when I read it, it's like I can't figure out what's happening, because everyone could be lying, everyone could be exaggerating, everyone could be making false claims merely for some other purpose. The amount of parents who will throw their own kids under the bus to get at an ex or whatever, and the kids themselves may have been gaslit, brainwashed, may not know what they're talking about. So who is reliable and who's not? What kind of accusations are true and what's not? I don't begin to understand on a fundamental level how you begin to even try to sort that out. So I can only hope the people that do it day in, day out have a better sense of it, because almost any field of law I can read and kind of understand at least. But child custody cases or family law, it's like, I don't know what to do with this. I can't figure out who's telling the truth. It's a whole nightmare. Plus, the standards are very loose, because the sort of biggest global standard on top of the whole thing is best interest of the child, which has a tendency of superseding everything else. And so I don't know how to evaluate that legally, because what the hell does that mean? How am I supposed to look at this and be like, oh, it clearly is or clearly isn't? It's like, it's I don't know what to do with this.
Yeah, and the problem with best interest of the child standard is that it's no standard at all. There is no objective measure of what the best interest of the child is. Arizona has put out some interesting, like they did a pretty in-depth study on things with custody and kind of laying out what the presumptive best interest of various age custody agreements would be. But that's not good in sussing out what the best interest of a child is in any particular case, especially when that case gets particular, right? Like this is just, well, at 0 to 12 months, it's really beneficial for the child to spend the majority of the time with the mother due to nursing and other stuff like that. And the father should have this amount of time, but maybe no overnights because of nursing issues and stuff. Yeah, and then as you get to like 12 to 24 or 12 to 48 months, that can change. As you get older, maybe they move towards 50-50 because that's in the best interest of the child. There's all sorts of, like, that's kind of a presumptive thing, but there is no objectivity in best interest of the child. And because who can say that their child is just like every other, right? No honest parent can say, oh, well, yeah, my child fits into the standard. That would be kind of disingenuous.
The infinitely elastic standard, how could they not?
Yeah. So the other problem that I have with family court, and this is a topic that I mentioned earlier, so maybe we should talk about it now, is and this is a constitutional question that I have for you.
Yeah.
How should we treat gag orders in family courts?
So I think gag orders in family court should basically be like gag orders anywhere. And I think that as a general proposition, I think they might be a little too frequently granted. I don't think they're widely granted, but still, I think the First Amendment interests, and even where they're granted, perhaps they're granted too widely. They could be more narrowly construed than just like don't talk about the case or something like that. But in the case of family law, I don't know how the analysis plays out because everything is so ugly and everyone's at each other's throats that maybe in that specific, also to protect the interests of the child as well, maybe in that situation, I don't know, because it's just such an ugly mess. And do we really need everyone talking to the plus? Because you've seen how depending on who has the PR, behind them at any point, how the PR can shift from one side to the other, seemingly radically and overnight for no particular reason. But one side has better PR, and suddenly the public is on their side where they were on the other person's side because they've been convinced by the PR, and it pollutes the entire perception of the honesty of the court and everything. I think this has been a factor in the Britney Spears case too. I don't know. I don't know for sure, because the general perception, as far as I'm able to determine it, is that the court is done something wrong here, that it might be corrupt, even on the take and all the rest of it. And this might go to my biases, which I've expressed before. I tend to assume the best of my profession. I tend to assume, as a starting point, that attorneys are honest and that judges are honest, because that's my experience and the vast majority of cases. So I go in with the presumption. So when I'm looking at the Britney Spears case, I'm like, I don't know how I'm supposed to evaluate this because I wasn't there. I'm not going to go read, however many filings it is over how many years to try to assess this independently, like I could even do that. And maybe the judge has very good reasons for what they're doing. So just to assume the judge is corrupt and all the rest of it, I don't know that the Britney Spears case is made better by being exposed to the light. I feel like maybe it's not.
Well, Jamie Spears has stepped down as conservator today.
Not exactly. He said he might when the current billing resolves, because they have to submit periodic things, and this is like the 12th one they've had to submit on. Here's all the things we've racked up. So Jamie Spears has said, I'll resign as conservator when that's all resolved, which is another way of saying I will resign when my lawyers get paid, so I'm not on the hook. So I don't know what that could, depending on what that fight could be, that would not necessarily be for, in a short time period. So, if I were the court, not that I know anything about it at this point, but given what limited I understand about family law, it's a very thin understanding indeed. But given what the new attorney is asking for, I'd be inclined to grant it. This looks like it's a professional conservator. He's well experienced. He knows how to handle large accounts. He has a forensic accounting background as well, which is probably going to be helpful as we're trying to evaluate, if anything improper happened along the way. And as I understand it, in the case of a conservator case, the conservatee is supposed to have as much independence and as much freedom as possible. The conservatorship is supposed to be essentially as narrow as it can be for the circumstance, and the conservatee is supposed to be able to have free will and express to the maximum extent possible. And so she said, I don't want you anymore. I want this guy. I'm like, well, this guy is exceptionally well qualified. There's no particular reason not to grant it. She apparently wants it. So, motion granted works for me. But, if the judge doesn't do that, I don't think it necessarily means they're corrupt. Maybe they know more than me.
But maybe
since they've been
not,
dealing with this case for 10 years, maybe they know more than me. So I'm gonna defer until I see something that's really, really wrong. Like, I'm beginning to at least begin to ask those questions in the Utah defense lawyer case, because I'm like, well, this seems odd. I don't really see anything obvious, but even now I'm still like, maybe there's an explanation that somehow makes sense, because I'm still willing to defer. But yeah, it's just, maybe it's a natural tendency of mine. So I don't know. I'm not sure it's better by being in the light. The freedom of speech interests, though, are a big concern, as you pointed out. So when it comes to family courts, I don't know. I'm in a position to express an opinion. It's a total nightmare fuel, and I just don't want to pretend it doesn't exist. How about that?
That's good. Here, let me help. Let me help with this. So this is particular to Texas, and this is the issue I have with, or one of the issues I have with a lack of transparency in family courts. Whoops. What the hell? Clicking the wrong buttons. Here we go. This is from last year in September, but this has been going on for a while. Federal judge says she will again hold Texas in contempt of court for failing to meet foster care reforms. Turns out Child Protective Services in Texas has had a class action lawsuit that literally put Child Protective Services in Texas under federal jurisdiction.
Cool.
Because they were so bad, because kids are dying in their care.
That's bad.
They have a failure to protect kids who need to be protected, and they're going after parents of kids who are not in the same level of danger. So this is the reason. This is my mild counter, and I don't mean it to be a counter to what you're saying, because I think everything you said was very wise, right? Like these are intimate personal issues. They're often very complicated. The public can never have a full factual record of what's going on, right? This isn't a contract dispute. This is how a family is operating. And so all of that there, though, but I feel like when you've got the government potentially removing the parenting rights of anybody, that's when we go, okay, wait a minute. I believe in transparency to protect the integrity of the system. At that point. And to me, so this is of course in a biased context. I'm talking about two cases that I'm covering right now, which is Sophie Long and also the James Younger case, which I'll be talking to James's father, Jeff, tomorrow. But I'm talking about these because both of these cases involved gag orders. And it's when those gag orders started are when things started going bad, particularly for one party. It's almost like the elimination of the ability to speak coincided with a decline in their performance in the case. And then the other issue is that once this case is resolved, and James Younger's case is resolved, the dad has lost custody forever of his children. And one of the ways I believe he's going to frame that is that he is fighting against what he would call the unconstitutional suppression of the right to speak in these matters. And here's the problem. So there's a gag order on him. He violates the gag order. Judge doesn't put him in jail. Judge doesn't punish him for the gag order, but instead just awards full custody to the mom in the best interest of the children. So was it actually in the best interest of the children? Is the judge just mad of his contempt of court and then therefore use the ability to strip the rights? Because if she puts him in jail, he can then he can appeal that. And he can say that this order itself is unconstitutional. But if the judge refuses to do that, we've got a different question going, right? Like, and you don't get to question best interest of the child because the appeals courts are really not going to try and overturn a district court judge's assessment of the facts.
No, it's unusual. It's unusual. I've occasionally seen a court of appeals whack around a family court, and I've seen them whack them around the First Amendment issues. But yeah, it's relatively rare.
But for First Amendment issues, they have to, basically say, okay, the gag order is unconstitutional, or the punishment related to the gag order is unconstitutional. Like that's about it. But what if the punishment is not legally tied to the gag order? And then there's nothing you can really do about it. I mean, you can talk and violate the order, but this is my issue with this stuff. So, so here's the judge. If finalized, the contempt finding would mark the second time in 10 months that Jack has punished state officials for being out of compliance with their demands, which are the culmination of a decade-long class action lawsuit that brought the state under federal court supervision. Her announcement followed a 2-day hearing held by video conference in which she frequently chided some of Texas's top child welfare bureaucrats. At times, she interrupted Paul Yetter, the Houston-based attorney representing more than 10,000 long-term foster care children in Texas, to emphatically agree with his assertions that the foster care system continues to hurt and endanger children. I'm actually stunned by the non-compliance of the state, Jack said, but I keep being stunned every time we have one of these hearings. The state's oversight of children's placements is in numerous instances lethargic and ineffective. The monitors wrote, there was a 363-page report. Operations with long, troubled histories of standard violations and child abuse allegations remain open and are permitted to care for vulnerable children, some of whom are then hurt. The prevalence of physical restraints and injuries to children in some facilities is simply shocking, as are numerous instances where DFPS staff document that the agency does not know where children are placed. But yeah, so I guess just my ultimate question in this is how much do we value transparency in the family court process? I framed it in a very unfair light.
Yeah.
But
it's a whole nightmare fuel. You
yeah.
know, and transparency, because there's considerations there to the child, and yeah, I don't know the answer to these questions. I feel like more transparency as a general rule is good. In pretty much every situation, it's just not my area of expertise. So I just want to pretend it doesn't exist. Family law doesn't exist. It's stupid.
I wasn't
Let's talk about some defamation or bad attorneys or something.
I was asking for your opinions, not your expertise. Okay. Let's see. This is from the Dragon's Treasure.
What's up, Dragon's Treasure? Your tea is awesome.
It is. It is very good. He says, "R.I.P. to the anime in anime themed tea. Someone contacted Shopify about me and they told me to gut my site of anything that may be infringing. So I did. This will be a huge hit to the business as people love to get their favorite characters or shows, not generic similar names. I've gotten worse hits though, so I'll find a way to manage. But this combined with Susan's recent hate boner for my YouTube channel is trying to suck out all the success this month has brought. The 5% to you is still on, of course." Well, I'm sorry to hear that, man. That sucks.
No, I'll say it again. Dragon Treasure produces a really good quality tea. He sent me many different kinds of tea, and I really, really enjoyed them. It's really top. It was really quality tea. So I recommend people checking out Dragon's Treasure. If you like tea, I think he produces a top quality product. So I think you should check him out.
So you're an IP guy, right?
I am an IP guy.
So let's talk about that. It's kind of an interesting subject. So there's a tea that I particularly like that he puts out. It's called the tea that pierces the heavens.
Ooh,
right?
I like that.
It's great. It's a very good tea. Now that is a line from Gurren Lagann, which is an anime. If you've heard of Neon Genesis Evangelion, which is a really popular anime, it's the same creator did Gurren Lagann.
Is it like a line that's repeated a lot in the show?
I don't think so.
It might make a difference in terms of like a trademark issue. So if it was like if tea that pierces the heavens was said a lot in a lot of different episodes to the point that it's an identifier of the show as such, then you could actually get into a trademark issue. That's why I asked the question.
But only if they're using the phrase in trade, right? Like only if the anime production company like puts out shirts that says the tea that pierces, or I think
they don't have to.
The
show itself is in trade. The show is trade. If the phrase becomes the trademark, basically at core is a source identifier, and so if a person hearing that phrase would recognize that source, and it can't just be like a one-off in one episode. That's not going to cut the mustard. But if it's something like for example,
it's
Star
technically
Trek, space to boldly go where no one's gone before. It's like, yeah, that's being repeated enough that becomes a source identifier.
Okay, what if it's serial that boldly goes where no one has gone before? So it's not the actual phrase.
I don't think you can, no. Yeah, I don't think that's close enough. I don't think it works.
So the phrase in the show is the drill that pierces the heavens.
Okay, and then you have the tea that pierces the heavens. Yeah, for my money, that's distinct.
Yeah, because obviously it's not the drill that pierces the heavens from Gurren Lagann. This is a tea that pierces heavens. It's different.
Yeah, I don't, because you're basically trying to really get at that point protection for the underlying phrase "pierce the heavens," and I don't think you have. I don't think that flies. For my money, on a trademark case.
Yeah, I think that's but then the question, so then we move out of trademark, would that be a copyright issue? I don't know if
No.
that's yeah. I was regretting saying it as I said it. So
No, I don't think it's a copyright issue because you are taking this very short phrase out of much longer work. And first of all, unless he acknowledges that it came from that work openly, how would you ever prove it? And it's just so de minimis as to be irrelevant for a copyright issue. So I'm not buying the copyright problem. That's why I asked the trademark question, because that seemed more promising.
yeah. Yeah, I think that's most of his stuff. But of course, there's a big difference between having a legal trademark issue and having someone contact Shopify and Shopify going, oh, you got to take it all down, right? Like those are distinct issues. Having your
Sure, it depends how conservative Shopify wants to be, and they apparently want to be very conservative, which is fair enough because it's their site and they can determine for themselves how much liability exposure they want. So if they want to take a conservative position to avoid the problem completely, that's a valid position to take. So yeah, it makes sense logically.
Yeah, so it's pretty interesting because I'm not aware of any of his teas actually using the trademarks of the shows or of the of the anime or manga or whatever that he's referring to with them. I think it's
Is he
basically
using specific character names?
I don't. I mean, maybe in some of them, I don't know. I'm not familiar with his entire catalog. I think I have all of it up in my up in my closet.
I mean, if you want to be even safer, then all you have to really do is to change the word pierce to something else. So instead of T that pierces the heaven, go find a synonym, or that will change it. So T that reaches the heavens, or T that surpasses the heavens, or just change that one word.
Penetrates the heavens.
Penetrates the heavens, maybe. Yeah. I'm not sure about that one, but you're the right idea.
The tea that penetrates heavenly bodies. I'd buy that tea all day.
The tea that helps you penetrate heavenly bodies.
Grazing Poro, thank you for the donation. There's no message attached. You probably got yeeted by Susan. Sorry about that. The Pie Baker says, hey, Nick, next to the big brain panel, there should be a second panel featuring replica Uncivil Law, Joe N-word, Percy the cane wielder, and Nate as the token black guy. We can call it Fists Up the Ass panel. Oh, God. Stop it. That's the Fuda panel. Not good. Thank you for that, the Pie Baker. Did we want to talk real quick about that? Yes, I wanted to talk about the issue in Utah.
Sure. Yes, we can talk about it.
Okay. So tell me what's going on in this thing, because I just saw, like I said, someone emailed me a thing about it. It was very confusing, and it involved a guy like showing up for court late.
Right. So this apparently resulted from a DUI, and I think at the time it had been going on for 3 years, which seems like a long period of time for a DUI to be going on. But he had public defenders, so his counsel was appointed by the state, and he had a 9 o'clock time to arrive for a hearing, at which point they were apparently discussing discovery. I mean, into a 3-year case. I mean, what? But okay. Apparently the purpose of the hearing was partially discuss discovery issues. Okay. So he was supposed to be there at 9. He was, in fact, not there till 9:07, but that's not where the end of the story is. And when I did my first coverage of the case, I got lost in whether or not the judge had made a mistake in terms of their ruling, and I got lost on a harmless error analysis in terms of whether you could reverse it because of what the judge did. And I said, no, you can't. And I still stand by that conclusion as to what the judge did. But that doesn't answer the question for the attorneys. So let's change our focus. And then when I took another look at it, I'm like, oh yeah, this behavior seems questionable. I'm not sure why they're doing it. Based on the tape, it appears that as public counsel, knowing that their client is not there, calls the case at 8:45, says we're ready to go. 8:45, we're ready to go on this matter. At 8:45, 15 minutes before he's supposed to be there. And this is not a special appearance. This is a cattle call. This is like for everyone for the day. So
yeah.
The courtroom is crowded with a whole bunch of defendants in a whole bunch of cases. And so his attorneys go up and say, we're ready to go. And they say, the judge says, well, are you not expecting your client to be here? It says, well, he's been late before, and so we'll issue an arrest warrant. Okay, issued. at 8:45, give or take, apparently. So the judge issues this warrant for failure to appear at 8:45, and then he's there at 9:07.
Can you even have a warrant for failure to appear prior to your hearing time? I mean, that's crazy.
Yeah, but I still think it falls into a harmless error analysis, and the reason I say that is because the judge could have issued the order at 9, and if she had done that, he still would have been in violation. So the fact that she issued it 15 minutes early is harmless error, because if she had done it right, it would have come out the same way.
Sure,
that was my rationale.
Okay. Yeah, by the way, I hate the harmless error rule. I mean, it's a rule. It's real. It functions, but my thing is when a right or a rule is violated by the court, I demand them to be perfect. Is my thinking about it.
Yeah, fair enough. And I got a lot of kickback from the chat and even some of my comments who say, you're clearly a statist, you're a bad guy, you want these people to suffer. And I'm like, at no point in my video did I ever express that I thought it was good.
Right. It's just how it is.
I just kept saying, here is the law. Let me explain the law to you again. Let me explain it to you again. No point did I say it was good, and no point did I express an opinion that I approved of it. I'm just here to give you the best legal education I can. Now, I did get lost on the issue, but I think I was correct on that issue. So,
well, let me contextualize it.
Yeah.
I can contextualize it in a different way. There are two rules on your first appearance. Basically, you have to appear before a judge within 36 hours, with a couple exceptions of being arrested. I thought
it was 72.
I think it's 36, but it comes out because they exempt Saturdays and Sundays. They exempt Saturday and Sunday and holidays. So if you get the worst time to get arrested is
It's Friday.
No, it's the Wednesday before Thanksgiving. At 12:01 Wednesday before Thanksgiving, you get arrested and you don't get seen until Monday. But there's that rule, but then there's a separate rule in Minnesota, at least, and I think it's pretty much the same everywhere because it stems from federal rules. But you have a 48-hour probable cause determination. This doesn't mean you get a hearing, but a judge has to review your filing within 48 hours. And determine whether probable cause is sufficient to hold you until your hearing. And otherwise you have to be let go. And now the interesting thing about this is if they fail to hold the probable cause hearing within 48 hours, and there are less exceptions because judges actually have to do these on Sundays in Minnesota. They have to pick up a phone and do them. And it's really easy. The prosecutor just calls and says whatever they want. And the judge says, okay, that's it. It's a pro forma hearing. If they don't do it, and your client stays in jail, even when they should have been let go, they will say this is a harmless error because unless somehow staying in jail prejudices the case, like your client dies, they say, but it didn't impact his ability to defend himself. It's a harmless error. And to me, it's like, wait a minute. To me, a deprivation of liberty is never a harmless error, but that's how the courts go with it. So it's something you have to acknowledge is a reality in practice. That doesn't mean that either of us support it. I think it's a shit rule.
Yeah, fair enough. So then turning our attention to the defense lawyers, they apparently make this say at 8:45 we're ready to go. They know their client isn't there. So they make this call even though they say we're ready to go when they're clearly not. The client walks in at 9:07. Sometime shortly thereafter, it was maybe, I'm not sure if it was 9:07 exactly, or maybe it was 9:15, but either way, shortly thereafter, he talks to one of his lawyers, one of the public defenders, and says, I'm here, and he says, we'll just sit down until your case is called again, or something like that. And then at the very end of the docket, it's the end of the day, so I think it might be 11 a.m. or something like that at this point. He's standing out in the hall for whatever reason. When he comes back in, he comes back up to the podium. They call his case again. He comes back up to the podium and says, well, before you go back, I just want to, berate you a little bit, basically. And his defense lawyer is standing there and says, so the trial judge says something like, we didn't see you till 10:38 or didn't see you till 11:15 or something. And the prosecutor actually says, I saw him at 9:38. She apparently ignores this comment completely, which is annoying. His defense lawyer at no point speaks anything. She doesn't say, oh, yeah, I saw him at 9:07 or I saw him at 9:15, as the case might be. So she's just sitting there silently. And he asked the question, well, when was the warrant issued? Which wouldn't really change the analysis either way, and he's taken back. And the implication has been the reason that they did this is because he wanted a jury trial, he didn't want to plead, and so his lawyers were trying to set him up to force a plea out of him, which he did eventually plead to. His brother or something gave him, because he was arrested, he was given a $15,000 bond, which he didn't have, because obviously he has public defenders, right? So he didn't have that money. So his brother or something lended him the money. His brother wanted him back. The only way to get the money back is to resolve the case. And so he pled guilty to resolve the case so he can get that bond money back. And now he's suing malpractice, suing the defense association. Now, I tried to contact the lawyer who's representing him in the suit against the public defenders to see if I could get a copy of the filings, because I went onto the court docket to see if I could download them, and this is where the state law docket systems are kind of bullshit. So Utah wanted me to pay them $25 just to set up an account. Then they want me to pay them $15 a month, and then they want me to pay for searching on top of that. So yes. I'm like, okay, well, this is why I like federal cases better, because I can search for free, and when I pull a document, it's capped at $3. So, yeah. And also, it's only 10 cents a page, and a lot of these states charge like 25 cents a page, which is ridiculous. So I contacted the attorney, said, could you just give them to me so I don't have to pay this exorbitant, extortionist fee from Utah, because I really don't want to, and I'd like to cover the case and see what's going on. Because personally, I'd love to know if the defense attorneys have any good defenses. Like, there was a strategic reason that somehow they thought this was a good idea for some reason, as opposed to like purely technical defenses. Because if it's purely technical defenses, I'm going to get pissed off. If here's a reason we did that thing, I'm like, oh, okay, that would be great.
I'm curious about the prosecutor, because prosecutors have a duty to disclose potentially not just exculpatory evidence, but when they know that facts would lead. But I guess the bench warrant's at 9. Or at 8:45.
The prosecutor said I saw him at 9:38, and there's no reason necessarily to doubt that. There's a still from a video that makes it look like he saw him, but it's not clear in my mind that he did, because his defense lawyer seems to be standing in the way of his line of sight, and it's not clear he was even looking specifically at him. So the prosecutor says, "Well, I saw him at 9:38." Well, okay, we'll take that as true, but the judge apparently completely ignores it. Yeah. And also, like, she also asked, well, when did we issue that warrant? And her clerk says, yeah, we issued it at 8:45, and the judge completely ignores it. Oh, we issued it at 9. That's not what the clerk just said. The clerk just said 8:45. And you're not paying attention to your clerk. You're not paying attention to the prosecutor. The defense lawyer is saying jack all. I think that's great.
The defense lawyer is at fault. I mean,
it would appear so. I'm going to continue to hedge my bets and try to assume the best. But if I get that response and they're just going on technical arguments, then I'll throw them under the bus.
What's the guy's last name? The defendant.
Oh Lord, why are you asking me questions like that?
Because it's a cattle call. They're going to go in alphabetical order.
Oh, I think he was. I don't think he was going to be first called. I think it was Gonzalez or something, but I don't know.
There's no way a Gonzalez is going to get called in the first 10 minutes of a cattle call. See, he was fine. Showing up at 9:07, he would have been there no problem.
Maybe the judge runs deeper. Maybe it's a random order or something. I don't know.
Man, in my experience, it's I've seen it two ways. I've seen it with alphabetical order. And then the other way I've seen it is sort of like matters. They'll clump matters together. If they've got a bunch of traffic tickets that are going to be really quick, or like maybe it's a bunch of first appearance. Well, they tend to schedule out. This is a first appearance hearing. This is a second appearance hearing. So I don't know how they're doing it there, but Sanchez is the last name according to the chat.
Sanchez. Yes, that's correct.
Oh man, that guy didn't need to show up till 10:15 at least. He probably could have shown up at 10:38 and still been on time. He's not getting called.
And his lawyer specifically asked for it to be called, and it was pointed out by other people commenting on my video. It would be highly unusual for a judge to issue a warrant at 9 o'clock if the person's not there. It is much more common, to the point of being universally common, for the judge to say, okay, we'll hold it over till the end of the docket. and then called again.
Or at
So
least 15 minutes. I mean, that's look, I had a client who was an hour late because they got on the wrong bus. This wasn't criminal, it was civil. But I'm there and I'm able to keep the court informed, like, really sorry, Your Honor, here's where they are. I know they're on the way, that type of thing. I'm here if we need to resolve anything. In the meanwhile, we can do that if my client doesn't need to be here for it. You're there. It's not like they're completely unrepresented and completely absent. I mean, that to me, it's a crazy thing. And I can't imagine a warrant that early. Yeah, just
and also
just
I
go
forgot to
put it on
I
the
forgot
bottom.
to mention even one worse detail. So he had two public defenders. Only his female public defender was there after like 9 o'clock, but the male public defender was there as well. And the male public defender said, basically said at 8:40, let's call the case and get a warrant issued. So the defense attorney appears to be saying, I am going to be calling the case early for the purpose of getting a warrant issued against my client, which seems like an odd thing for a lawyer to do to their client.
Yeah, that seems like malpractice.
Yeah.
I mean, just that seems like clear malpractice. So, okay, so wait, the bond was then issued in relation to this warrant that was issued?
Yeah, it was issued. Yeah, it said in one breath, arrest warrant, $15,000 bond.
And so then he borrowed money from the brother, pled out his case. Against
Gets the bond money
wishes.
back, so he can pay back his brother.
He couldn't get a. Yeah, I guess. God, what a disaster. I don't know. The question is, what are the damages? Like, what are the malpractice damages there? You got deprivation of liberty, which that actually is a pretty high damage. Like, being incarcerated for a day is probably worth more than people think. When you're bringing it against a lawyer.
I think Sanchez said he was offered $40,000 to settle. So I don't know.
Now they get to sue the state on this because it's the public defender's office, right?
They're suing the office, which has a name, so they're not suing the state as such. And I don't know how it is in Utah necessarily.
I wonder if it's like an appointed private attorney.
Yeah, it might be. I don't know exactly how it's set up in Utah.
Yeah,
it's not called the public defender's office. I think it's called something else.
Sure. Yeah, there are people around here who will take appointed cases just through their law office, but they take a fixed rate from the state rather than being public defenders. Well, that's crazy, man. Yeah, I mean, to me, you've got obvious malpractice issues. Just asking to call the case prior to your client being there, even if you think that the sanction for your client won't be a bad one, like, it just makes your client look bad and it puts them in a bad light in front of the judge. Like,
yeah, so I want to hear their explanations, and I did see at least their public statements from the lawyers representing them, who said that this is clearly frivolous and omits essential facts, which I'm not sure what those are because we have a tape of the thing and seems to be, I'm not sure what essential facts we could be missing. But I'm going to reserve my condemnation until I read their response and see if there's something there that makes sense. And if there's nothing there that makes sense, yeah, I understand. I'm going to take a slightly more moderated approach because I want to believe the best of my profession. I want to believe that they're honorable and they're trying to do the right thing in some sense. And so, I don't want to second guess without cause. So I don't want to second guess you.
My second guess of attorneys is when I'm going, wait, maybe they were acting correctly here. I have the opposite approach. I think they're all terrible people. So I'm so done with attorneys that I don't know. My immediate gut reaction is they're bad. Like, so that's where I'm going with from now on. I'm done with it. And it's serving me well so far. Because like Laura Elkind, that lady can get wrecked for all I care.
Yeah.
And I have I have nothing but contemptuous things to say about most of the attorneys that I keep running across. Oh,
Well, I guess my experience is different than yours then.
well, you've got to be a little spicier to get the really shitty lawyers coming after you.
Fair.
No, I mean, I actually respect the work that public defenders do. I think they take on caseloads that are I'm going to say it in a bad way, borderline malpractice, but it's not their fault. They're just underfunded and understaffed. It's malpractice of the state to employ public defenders' offices in the way that they do, in my opinion. But so I think there's merit there. But at the same time, when you agree to that reduced fee case, or if you're appointed, or that salary that you take as a public defender, where you're not bringing in business, it's coming straight to you. You take on an obligation to represent your clients with zealotry and to the maximum of their defense. And it doesn't sound like that's what happened in this case. And I can't think of a reason they would do it in the way that they did. Like just at first glance. Do you have any inkling of what they might say was their reasoning? Like if you had to throw a wild pitch, right? What do you got?
I got nothing.
Yeah. I can't think of anything either. What possible excuse could you have? My client's not here, Judge. We're ready to go, though. Okay. In a criminal case, like in a civil case where it's like just some motion hearing, it's not evidentiary. You're not going to have the client testify. Okay, sure. My client's not here, but they're not coming, Judge. We're ready to go on this matter. But this is criminal.
Maybe I'm just holding on to the hope somehow that it all makes sense and we're all missing something. So yeah, maybe I'm foolishly holding on to that last bit of hope.
Oh,
So,
you sweet summer child.
I was born in January.
Oh, you sweet winter child. Okay. Well, that's the main topics I have for tonight. I've got super chats, but I know it's pretty late,
Yeah,
so I didn't know.
I'm beat, man. I'm gonna bail.
Yeah.
Well, I'll just simply say I enjoyed being here to everyone here, and remember to check out my channel. The name is right there, Uncivil Law.
It's also in the description. You can
click it, subscribe.
It says at Uncivil Law. Just click on that, and it'll take you right to his page.
I'd like to siphon off some of Nick's 170,000 subs. Brother, can you spare 10,000 subs? You know what I'm talking about there? Yeah. So yeah, unsubscribe here, subscribe there.
Wait a minute. Nails it. My camera, has it been out of focus this entire time? I'm like focused way up here. Oh God, that's close. Oh my God. Okay. So, ditch this. I was going to make an announcement that you guys are really close to 1,000 likes, but you passed it. I pre-poured the shot. I was ready to go. Thank you so much. Guys, you have no idea. My office is cold. It's freezing in here. It's almost uncomfortably cold, but I am digging it. I am digging it, man. I got my AC going. It's got a remote control right here. This little remote control. I can, oh God. Oh, it's 69 degrees in here, like always. And it's so great. It is so great. I can't take it. Can I? I don't even know if I can focus back here. I have to use this little wand. Not a Hitachi wand though. Okay. It's a little bit better. Now I don't have to be so close on that. But yeah, so it's beautiful. I'm just sitting here basking in the cool air and I couldn't be happier. I will be on Twitch tonight. It's game night, despite what Bainling wants to do. We've done movies. Movie nights are Mondays and Wednesdays, and we also did a movie on Tuesday after some gaming. But it'll be a game night tonight. Not quite sure what I'm going to play yet, but we'll figure something out. It's not going to be Doki Doki. My voice is actually ravaged and has been for several days. And so I'm holding off on something where I have to read through a ton of stuff. I don't know what's going on with it. I think I'm just I got a couple days in a row of like 2 hours of sleep, and I haven't really caught up from that. And I noticed that when I get less sleep, my voice gets a little bit more tired and raspy. So I'm and it's such a weird thing to complain about, but I talk for a living and I talk for an extended period of time. And so I notice it pretty quickly right away. So we'll find something to play tonight. It'll be fun, but I'm not doing Doki Doki because I'm not going to sit there and do all the voices. That's a pain for me. But there are some games with some updates. There's some new games that I have. All sorts of stuff going on. Hey, what's up? Rescue Michigan says it's Adam D. Speaking of bad defense attorneys, started my own channel, now getting flack for calling out a wacko who got arrested for posing as a lawyer for a lockdown protest defendant. Let's talk about the constitutional lawyer. Oh my God, I heard about that guy. Yeah, he's an unlicensed guy pretending to represent people. Yeah. Excalibur says my central AC's at 68. Get bent, you weak. Get beat, you weak loser. I could drop this to 67. It's just funnier at 69. Punk. Take that. Take that. So yeah. Yeah. Yeah, man, I'll send you a message. I'm going to talk. We should talk about it. That'd be great. So your channel is your channel Rescue Michigan? What is your own channel? Tag me in the chat so we can get people over there. Adam D is a very good guy, by the way, guys. He's one of the people who turned me on to Lucas Gerhard's case, which is still pending. And he's been an important guy in Michigan. Also was the source, right? We talked about this on the show. This isn't a secret, but he was the source on the Detroit leaks. If you remember the Detroit leaks, that was where someone went in and recorded the election training that was going on in Detroit, where they were intentionally going to use COVID restrictions to restrict access to the ballot judges and election observers. And we aired that video on the channel here. We interviewed and talked about it. The actual original video got taken down. So I believe the only place you can watch that video on YouTube is still on that interview here on this channel. So it was a pretty big deal. Pretty big deal. But he did say his channel is still Rescue Michigan. So go check it out over there. Check out his stuff, because he's a good dude. And yeah, man, we'll have to get you back on and talk soon. Okay. That being said, we now have a bunch of super chats to read. Remember that tomorrow, guys. Tomorrow is going to be I think a heck of a show. Jeff Younger, the father of James Younger, that is the Save James kid, who is whose mother wants him to be Luna. His mother dresses him in dresses and has for several years, and wants him to be Luna. The dad says that's crazy. The dad has said that at his house, where James is able to choose what to wear, he chooses shorts, pants, shirts
even though dresses and stuff are available. So Jeff will be on here. He is taking up the cause of dad's rights, I believe. And all it cost him was the rights to his own children. And it's a nasty system. He's been under a gag order forever. And we'll be talking about all of those issues. This is all going on in the Texas family courts. And the Texas family courts seem to have some really big problems. I've heard the mom isn't the biological mom as well, but I don't know anything about that. So I'll ask him tomorrow, or you could ask him, either way. I think that's a question we can get directly from him and answer on it. So I spoke to him briefly today to set up the interview, and I think he's ready to share, his whole story. So hopefully we can get the whole story out of him. And I think, bring the leather to bite down on, because this story is probably going to piss you off. Mr. D, that's right. You nailed it. Yeah, if you guys ask him, I get $20 more. No, I'm just kidding. I'm going to try to remember to ask him. I just, when I get into a conversation with someone, I don't always remember everything I wanted to say. And who takes notes and plans for things? So that's going to be a pretty big deal. I think it feeds into questions about the Sophie case. I really think it does. This idea of courts gagging dads from speaking out, and then all of the rulings start to go against them. I mean, here's the crazy thing. Jeff was actually awarded custody of James. People may not remember this. He was awarded full custody. And then like a month later, the mom refiles and suddenly he gets no custody ever again. So that's how family court works. It's another critical difference between family court and everything else. In every other instance, in every other civil court, once you have a final order, it's over. The matter is resolved. In family court, all you have to do is plead that there's been a sufficient change in circumstances for the court to relook at the issue. One person moves a block away. Someone gets a new job. Someone gets a raise. Someone gets a different schedule at work. If they're union, they bid a different schedule. Sorry, you could be going to a family court to get that resolved. And it's absolutely insane that this can happen. But he went from being awarded full custody to being stripped of his parental rights. And it's disgusting. It really, really bothers me. So that'll be tomorrow's show. Let's do super chats and justice chats and then wrap up tonight's show. That sound good? I hope that sounds good, because that's what I'm doing. Tridio says, in Kermit voice, try not to do voices here, but this is sent a long time ago. Baneling, why are you still here? My boy Trump fired you last night. Oh, well, wasn't bad enough you're born Indian. You have to also simp for Blizzard. Good news. Looks like they're looking for a new sexual assaulter in chief. Go get it. What? Okay. Good job. Good Rat says, ran my Ridge wallet through the washer. My cards still work and they were barely wet. Buy a Ridge wallet, friends. Oh, yeah. A washer's not going to screw up your Ridge wallet. You're still going to have a good quality product after that. And I'll say, even though it's not true, they guarantee it against washing machine injury and death. Because I said it. It's a joke, by the way. I have no idea what they do. But no, they're metal, guys. Well, this is some sort of, I don't know what it is. Doesn't really sound like metal, but it's called carbon steel. So I think it's a metal plating, I think, over a piece of plastic, some metal screws in there. But yeah, what's a washing machine going to do to this? Nothing. But yeah, this isn't a Ridge ad, by the way. That's coming in a couple days, probably, or a couple weeks. I don't know. We'll figure it out. Okay. ASMR Ridge ad. Yeah, here we go. Here we go. Oh, you probably can't even hear that because I got the noise gate on. There you go. Carbon fiber is not carbon steel. Whatever. Look, what do I look? If I was a materials engineer, do you think I would be sitting here? I probably would be. It would just be a different theme of the channel. Raid or nothing? What do you mean raid or nothing? Are you talking about Raid Shadow Legends? I actually have a Raid Shadow Legends grift stream 1 week from Tuesday. So I hope you guys are ready for that. That'll be on Twitch. A full-on Raid Shadow Legends grift stream on Tuesday of next week. I will be playing Raid Shadow Legends for 2 hours, no matter how much I hate it. So that'll be fun. But it'll be on Twitch. Sellout? Hell yeah. They're gonna pay me to play Raid for 2 hours. We're gonna do it. Eldon Bainling, I did not say I would do a locals Ricaid Law whiskey. I said I would like to if I can make a certain deal happen, but it's going to be something crazy. Dalacourt, I did it all for the nookie. What? The nookie. What? You know what I'm talking about. All right, here we go. Arnold loves Nazis, says in Trump voice. I'm disappointed in Arnold Schwarzenegger stating, "Screw your freedom." Arnold is such a Nazi. I'm not surprised. His dad was a Nazi. Kind of maybe runs in the family a little bit. Not surprised, not alarmed, just a little bit upset, maybe even disappointed. Arnold, go screw yourself, you Nazi. I hope you get Epsteined in Roblox while I bang Melania. Have fun with your Maria Shriver. Take that. That one guy says, as shitty as you guys make our legal system sound, don't get me wrong, I'm still sure it's the best one. I don't think I would do anything if I was sued. I just let the judge do whatever. No money for a lawyer and no faith in the system. Waste of time. Yeah, well, you'd get a default judgment and then they'd have to come after you for it. Will you read the Raid Shadow contract? Ron made that contract. I have to see if there's an NDA attached. Oh, I was going to go through at some point the multi-channel network contract that someone sent me. It was a multi-channel network. It's the biggest one, I think. They sent it to me trying to get me to sign onto their program, and I told them no. I was thinking about doing that. Maybe I don't know if that'd be an interesting show, but maybe. Not Madcast Media Network, BBTV. BBTV. Fuck mask mandate says in Trump voice, hey, Uncivil, how many receptacles on the Federal Unemployment Tax Act, 2 or 0? Also, Uncivil, does getting buck broken, does it make you gay or not? Really a good question. Lots of unanswered questions about buck breaking. Kind of a new phenomenon, but maybe an old one. Maybe a little bit of the new, a little bit of the old. Kind of a thing going around. Okay. Gundam touched me. Says, here's $5. Now hop in a hot tub and get touched by Gundam. Not applicable says it probably leads to a catheter the most, to be honest. Kim Berger says, you guys are so funny. You should always do shows together. Jackson Kai says, if it moves and it shouldn't, duct tape. If it doesn't move and it should, WD-40. Lubricant solve half of all problems. Nick is correct. Abahind says, you couldn't wait until Nurkish's live stream was over. Rude.
He was watching a video about a fat ballerina. I feel like your voice is needed. I didn't know Nurkish was still streaming. I didn't know that was a thing that was still happening. The Real Holzenator says, congrats, Ricada. Your video with Arch has earned you more subs. Never heard of you before that. Keep up the good work. Oh, you subscribed after that? Trash fire? Thank you. You are truly a saint. I'm going to have Arch back on because my internet got cucked harder than Toye. And so that's a joke you won't get, but that's okay. My internet got just blasted in the middle of that thing, and it was so frustrating and disorienting that I want to have Arch back on to have a proper discussion about things. Maybe not just limited to the topic of Warhammer, because there's a lot more to discuss. Not applicable says Apple doesn't fall far from the tree. I think he's talking about Arnold. XL Art says, Nick and Uncivil, what are your thoughts on definitions for words being changed to their woke meanings, and what can we do to fight back? Well, not much. Start your own dictionary. Just build your own dictionary, Webster. The Urban Dictionary exists. I mean, of course, there's nothing you could do to create a dictionary that would give it credibility. And the dictionary Gestapo would probably prevent your dictionary from ever seeing any sort of legitimacy. But hey, you can just make your own. Just build your own dictionary. Just build your own language. How about a live stream with me, Tex, Arch, and Razor Fist? Sure. What, all talking Battletech? I could have them all red pill me on Battletech. I mean, definitions for words change over time because we allow them to change. I don't know. Resist change. I don't know I don't know how to fight it. I really don't. Start your own Snopes and don't name it something stupid. That way people can point to conservative Snopes and dismiss lefty conspiracy theories. Play Vermintide tonight? Maybe. Malik Foxon says, my dad just got through telling me to listen to fact checkers regarding COVID. Oh my gosh. Whew. 127 Chinamen can't be wrong. God help him. Tell him about World War II Austria. Winston says, Kurt, can you explain harmless error? I heard some people struggle with the concept. Okay. He kind of did, but I'll do it here. A harmless error is an error that occurs, but doesn't cause harm to the person who is wronged by the error. So in the case of the Utah defendants, like Kurt was talking about, if you issue a bench warrant at 8:45, but the appearance is for 9:00, it's technically an error to issue the bench warrant 15 minutes early, right? Like that is incorrect. But if you could issue the bench warrant at 9:00 rather than at 8:45, and the person still would have been similarly situated, then the error exists, but it's harmless to the person. So there's no prejudice to them. It's not like there would be prejudice if like every 15 minutes it added penalties, but there's no error there. If 9:07 would be equally wrong, equally late for both 9:00 and 8:45, then the error is harmless. That's not the correct thing. Like that's not morally or ethically correct for courts, in my opinion, but that's what courts do. So. Levi King says, in my experience as a lifelong Mississippian, our courts don't give a fuck, and I wouldn't test them. I wouldn't test most courts. Tony Neve says in Mr. Y Voice, now that Officer Sicknick didn't die, can Uncivil apologize for saying he was hit by a fire extinguisher? He also wasn't escaping in Georgia. Caleb Crow says, can Veritas supplement / refile their lawsuit based on things learned in discovery, even if New York Times wins dismissal on appeal? Probably not. Probably not. The denialist says a voting machine is just a database and a calculator. How could those be trade secrets? I'm not saying they are. I'm saying they'll argue that they are, though. Not applicable says, chat, don't admit to crimes, you idiots. Stop. Just for reference, that was about me asking how much a prostitute costs, how much people have paid for prostitutes. Admitting to the crime would be admitting to specific dates and all of that stuff. There'd be a lot more to it. Roman Reyes says, was this drawing corn or IRL corn? I don't know. Eldon Bainling says, Nick Senpai, what movie are we watching today? We're probably not going to watch a movie. We're going to play a game. Matthew Harder says, Ash Ketchum wanted to know about cigar recommends. I like Cuban. My selection are Cohiba, Montecristo, and Romeo y Julieta. Honduran is good too. Oh, I've had a Cohiba. That was good. Very good. Ready to Kill says, Nick butchered the name Gurren Lagann while it was squealing and very much alive. Did I say Gurren Lagann? I don't know what it is. Icon of Sin. No, Brigador does not work. Eldon Bainling says, by the way, Nick, Legal Bites was interested in doing a stream with you. She said as much on her last stream with Nate. Consider having her on. Sure. Victor Phantasm says, I'm part Korean, and part of our culture is not to look people in the eye when speaking. I've met 2 different judges, and they asked me why I never looked them in the eyes. What do I say to not be sus? I think you just tell them. And what I would say is, as part of my culture, out of respect, because I think I'm presuming here, but I think it's not just not looking people in the eye, but isn't it also kind of specifically with people in authority and people in positions of trust and respect and maybe honor, like a judge? I would suggest, out of respect, in my culture, we do not look people in the eye. So please understand that if I'm not looking you in the eye, it is out of respect to you, not out of disrespect. So, and yeah, Victor Phantasm says, yes. I would also maybe throw in, culturally, especially to positions of authority and honor, we defer respectfully and we do not look them in the eye. We do not look people in the eye out of respect. I would just explain it. It's a cultural thing. It's how you grew up. And that's something that's a mannerism that's really hard to overcome. And I think the judge will probably be accepting of that if you explain it, just logically to them. Master Blaster says, lawyers, honorable, pick one. Oh, no, I will not. Grazing Poro says, hi, bad boomer here who didn't send message. Any ACAD messages, hit me up. Oh, academic messages, hit you up. Love all that you do. Hey, thanks, buddy. Really, really appreciate that. Jackson Kai says, as Viva Fry put it, these are the 96% of lawyers that make the 4% look bad. Yeah, exactly. Cleveland Steamer, welcome to Paralegal Status. Thank you for joining the channel. Victor Phantasm says, Nick and Uncivil, people in chat have asked me to elaborate a bit. I had 2 misdemeanors, had to face a judge personally. How do I tell judges it's rude to look them in the eye for my culture? I think being, as weird as it sounds to say be direct when you don't look people in the eye, it is beneficial for you to just be direct or and let them know that's why you're doing it, because you don't want them to take it the wrong way, right? Like you don't want them to be offended and think you're disrespectful when you're trying to be respectful. So I would just be very open and honest about it. Death Trout says, I realized I might have the coof when I couldn't smell the Dragon's Treasure tea I bought. I was right. Tested positive yesterday. Damn. Good luck, buddy. Hopefully the 99.9% will be on your side. Matthew Harder says, Nick, I'm a proud Texan and I wish to do justice where the state cannot on these cases. What should Texans do? Why not take justice into our own hands? I cannot advocate vigilante justice. That's against my ethical responsibilities. I think everything should be done in a legal manner and according to the state law of the jurisdiction that you're in. That said, right to Governor Abbott, right to Ken Paxton, right to everybody that you can. And I think we're going to hear about some interesting stuff that's been going on tomorrow from Jeff Younger. Texas Red says, if you spell fiber as fibre, you're a Eurosimp. Good Rat says, baseball is the last semi-based sport except for Cleveland. How can we save our sports ball? I don't think baseball is actually that based. I don't know. I don't know that it can be saved. So, yeah, sorry, man. I just don't know. Fuck Games Workshop says, hey, Uncivil, what the trademark law for Games Workshop taking down Arch for name Warhammer? Unfortunately, it's under Europe. It's under UK law. That's the problem. In America, they would have a real issue with it. In the UK, who knows? Also, what's the trademark law for Games Workshop extorting creators to work for them or get sued because of fan creations? In Trump voice, the executive of Games Workshop should get Epsteined in Roblox. Roblox, a little game kind of like Minecraft, but not really. Lots of people make it. It's an economy now. Yeah, again, they're utilizing UK intellectual property law, which is different significantly than the United States. And that gives them, unfortunately, a lot more power. Buttfucker 3000 says in Trump voice, you see, Brett Blooms is such a retard. Why would you use your work email and your real IP to watch child pornography? Brett Bloom, such a horrible person, while Jeffrey Middleton, a wonderful judge, punishing retarded abusers and lenient on Buttfucker 3000. Terrific. Look, honest mistake, a little prank from a sibling. Never hurt anybody. Never hurt anyone. Kool-Aid Man says, oh yeah, Nick, can I help out the dragon's treasure? Just give me the info and I'll go to the houses of all those people trying to keep him down, bang their wives. Then I'll slap a saddle on Mommy Susan and break that horse. All this with a T in my pitcher. Gross. Mr. Y says, oh, your throat is sore, Nick? I'll make sure to be more gentle next time. Tell Drexel I said hi. Gross. Gross. And the Pronato says, I have no hard feelings for Raid since Count Dankula said he's correct that they have done more for independent creators over the past years than YouTube itself. Yeah. I like any legitimate company that wants to sponsor me. I really do, because, I say things that make people uncomfortable from time to time. Dave Youngson says, is it me, but do Greer and Toye look alike? Well, that's probably because the calls are coming from inside the house. No, they do. They do actually look alike. That's a real thing. And yeah, other similarities as well. But there you go, guys. That's the show for tonight. We'll see you guys over on Twitch. Thanks for hanging out with me. Oh my gosh. Let's do this way. I need to get this song easily playable. All right, share screen. This one with audio. Okay, guys, I'm going to go do Twitch, but I'm going to play this outro song. I'll catch you in just a minute, all right? Hope you guys have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he begins the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she'd make sure that he has the time and the place to provide for them there. So pour out an Ardbeg about more of the frog. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. So pour out an Ardbeg about more of the frog. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. From the white